My lord, may I have your lordship can leave to mention, my lord, application in connection with the new application.
New application.
My lord, may I permit to mention, my lord, without certified copy, my lord, we have preferred an appeal, my lord.
What is the urgency?
Urgency is, my lord, petitioner participated in the NEET exam, my lord. My lord, as per, my lord, there, my lord, OMR sheet, my lord, my lord, she once got this number, my lord, 580. Instead of 580, my lord, he got the 128, my lord. My lord, entire, my lord, counseling has been started, my lord, without, my lord. We want to, my lord, one seat is reserved, my lord. 4th June, my lord, they have
What
sent.
did the single judge say?
My lord, 4th June, my lord, they have sent OMR sheet as per.
What did the learned single judge say?
My lord, they have, my lord, investigation, my lord, refused this, my lord, interim order. One seat is, my lord, one seat is vacant, my lord, because, my lord, counseling has been started.
So writ petition is pending.
My lord.
Your injunction has been refused. You're coming up against that.
My lord.
So your appeal is not maintainable. There has been no final adjudication of the issue. How your appeal will be made?
No, my lord, refused, my lord.
Leave granted. Yes.
For inclusion of new application, my lord.
New application, please hand over this.
Lordship, group 2 hearing matter for inclusion, my
lord.
New
Mention on the next week.
Lordship, my lord, he is
Hearing of
hearing matter group 2, my lord. Since 2022, my lord, it is pending.
Chalo dear. Are you mentioning about notice?
My lord.
Give the notice. Combine list.
Lordship, upgradation matter item number 70, 71, 72. Early occasion I have mentioned. Your Lordship tell me to mention that.
70, 71, 72.
Similar matter, Lordship. Petitioner wanting to switch over.
GPF. The teacher is alive. Pension holder is alive.
No, Lordship. Petitioner is.
Now, who are before? Wife, widow, and sons.
Wife.
When did you file the appeal? Appeal was of which year?
Lordship, appeal is of 2024.
24 appeal.
Upon notice.
Combined list to call holo তখন কোথায় ছিল?
Monthly list was called
2004. 3rd February 2004.
What is the urgency, madam? No urgency.
No, Lordship.
Puja vacations are coming. That's the
Gratuity
urgency.
amount did not release in favor of the petitioner.
What is the urgency?
and the list was called. Where were you? Entire combined list was called. Let us see. If we do not reach, you mention us next month. Let us see how can we accommodate you. There is no.
Your Lordship, this is a matter pending since 2023. Your petitioner has filed a writ petition, but the writ
What
petition.
you are mentioning, madam?
I'm appeal.
Appeal of which year?
2023.
23.
Yes, Your
Paper
Lordship.
books filed.
Your Lordship, I'm not aware
Then
of
how you are mentioning, madam? Have you given a notice to your other side?
Yes, yes, Your Lordship.
Is it an application or the appeal is to be heard? That also you don't know, madam. Have you seen the brief?
No, Your
Please
Lordship.
go through the brief, ascertain yourself,
Yes,
then give a notice to your other side and mention next Monday. Yes.
Yes, Your Lordship. Your Lordship, may I be permitted to mention two urgent matters for filing without the certified copy? Your Lordship, these are both transfer matters, group 2 matters, where the writ
Two
petition-
appeals.
No, Your Lordship.
One appeal. When was it dismissed?
Disposed of on Your Lordship 13th October, 13th August.
13th August.
Certified
Trans-
copy, we have already applied for the certified copy.
So what is the urgency?
Your Lordship.
They have already transferred you.
No, Your Lordship. The
Leave granted. Call the list.
Lordship, item number 1, learned senior counsel, Mr. Piyush Chaturvedi is for the
First thing in the morning, you come and pray for adjournment. First thing in the morning.
Lordship, this is what I have been
So
instructed.
we will dismiss it then. This was there in the list. You people are not coming to us.
Lordship, due to some
Call him. Who is your senior?
Lordship, he is not my senior. I
Then-
have been instructed to pay for a day's
So
accommodation.
who is that gentleman who has instructed you?
Mr. Piyush Chaturvedi,
Who's the advocate on record?
Mallika Manna.
Where is she?
I don't know, Lordship.
Pass over. Call Mr. Chaturvedi. Yes, next.
That should adjourn.
সময় নিতে চান আমার this matter may place the facts, man.
Just one.
My lord.
Which is the order impugned?
That is at
Page 93 of the stay application.
my lord.
Sir, give us 2 minutes. Give us 2 minutes.
My lord.
Sir, buddy,
My
after
lord.
a long litigation, you obtained an employment. See how you are behaving. After so much of litigation, 2016 to 2025,
My lord, I will place the case, my lord. Kindly.
you got. Now you are trying to exercise another aspect of the matter. Why you are not, sir? Go and join. Apply for transfer.
My lord.
Why a person is getting a job
that
You see, you're finding fault with again what
is
has
true.
been.
They have also conducted them contrary to the rules, my lord. That's why I want to place it, my lord. Kindly allow me, your lordship, kindly go through the order, my lord. Kindly allow me to play for 5 minutes, my lord.
Conduct is not appreciated. 9 years you were sitting at home, and after the court passed that order, you got an appointment, but still you.
No, my lord. I am working.
Attitude is not proper.
I am working as a primary school teacher. Presently, I am
Then
working as a.
continue to work, sir. What is the problem?
No, my lord, kindly place my case, my lord. So kindly bear with me for 5 minutes only, my lord. May I place the case, my lord?
এত বন্ধ করে এসব পেয়ারে চাকরিটা নেই না আমার
Male female category. Well, kindly visualize. OBC A male female category.
ওবিসি এ
A male female category. They are selected as a waitlisted candidate. The counseling rules is, the authority shall ask the impanel candidates. They will appear in the counseling process. They will choose. They will exercise their option. Once a candidate participates in the counseling process, they will not get any second chance. Either he opted or declined, whatever may be, he will not get any second chance. Now, in this case, on first phase counseling was conducted on 27th September 2024 to 23rd October 2024. In the first phase counseling, the School Service Commission, kindly
27th October to
27th October to 27th September to 23rd October. Well, kindly take up my supplementary affidavit. I prepared a chart to that effect. In my supplementary affidavit, I have prepared a chart. All 3 counselings. Page 5 of the supplementary affidavit. Page 5, Lordship, kindly see, of the supplementary affidavit.
supplementary
Yes, my lord. On supplementary affidavit, I have filed annexing the chart, my lord. Page 5, my lord. Kindly see.
page 5.
5, my lord.
Yes,
Must have got it? Yes. The first phase counseling was conducted from 27th September to 23rd October. This is in respect of only OBC A male female category for the subject pure science. I have prepared this chart. Now, my lord, in the first
no,
phase
I didn't understand. Date of notice was 27 September to 23rd October. Period of counseling was from 3rd October.
October to 11th November. They called 427 impanel candidates in the first phase counseling.
All waitlisted.
No, impanel candidates. They are impanel candidates.
Very good.
Well, during this first phase counseling, there was at least 4 schools. Nobody opted for that school, or the post was remained vacant. The rule said once the post is remain vacant or nobody opted for the school, they will include those vacancies in the next counseling or any subsequent counseling. They have to include in the rules. I will show the rules itself. Now, in the first phase counseling, 4 schools in the district of Malda, they did not include. Now, second phase counseling was conducted from 27th October December to 23rd December. They asked 164 candidates. Those are impanel candidates. In that second counseling, they did not include those 4 vacancies. Now they call for third phase counseling. 53 impanel candidates, because there are no other impanel candidates. Only 53 candidates were left. In the third phase counseling, the 53 candidates, they conducted counseling. In the third phase counseling also, they did not include those vacancies. Now, my lord, thereafter they called, my lord, waitlisted candidates. In the waitlisted candidates, my lord, though in the third phase of counseling, petitioner appeared as the waitlisted candidates.
Fourth phase.
No, they appear in the third phase counseling. With
If-
the 53 impanel candidates and the rest are waitlisted candidates.
How many candidates? Listed?
That waitlisted candidates, 200 something. Well, that I've
Yeah.
prepared I have annexed the entire list of waitlisted candidates.
Second phase onwards is waitlisted. Only first phase is for empaneled candidates.
Second phase onwards, it was waitlist.
Yes.
Well, the petitioners were called in the third phase counseling.
They were not calling the second phase.
No, that chance was not there in the second phase counseling because before me, so many waitlisted candidates were there. They called up to that candidates. In the third phase counseling, the petitioner's chance came. Well, in the third phase counseling, all the waitlisted candidates exhausted. There was no other candidates was left, either impaneled or waitlisted candidates. So they are supposed to include those vacancies
But you participated in third
in the
phase.
third phase counseling.
So vacancies which were there were utilized by the persons called from impanel list and from wait list.
Waitlisted.
All you were
Yes.
also given a vacancy.
Yes, my lord. But at that point
Where
of,
you were recommended,
yes, I have recommended
where
them.
you are working as primary teacher.
I am working as primary teacher in one in the Malda district and another in the district of Uttar Dinajpur.
And 2 appeals have been filed.
No, 2 petitioners are there in this. In this petition, 2 petitioners are there.
So you are working at Malda. Now
Yes,
which
one is
one
Malda,
and Uttar Dinajpur. So
Yes.
which schools did you choose during counseling?
because only two schools are left. No other option was there. One like in the Midnapur.
Yes, take your seat, madam. Take your seat. Sit.
One in the district of Midnapur and it's more than 400 kilometers away from
Very
the.
good. Now
have
what
vision.
happened?
Now, my lord, after the third phase of counseling, I came to know that there was at least 4 schools in the district of Malda, which is nearer to the petitioners. They did not include in the up to third phase of counseling. Now, my lord, I inquired from the concerned schools where the
In what case you have made out in the
Yes.
petition? Take us to
Malad,
that.
yes, my lord, I'm coming. I'm going 1 minute. But I inquired from the concerned school. They said, though there was recommendation, nobody joined, and the school authority intimated such fact that nobody joined in our school to the School Service Commission, to the DI of schools. Both of them they have intimated. So after receiving the intimation, the School Service Commission was supposed to include those vacancy in the subsequent counseling. But my specific case was, since up to the third phase of counselings, the candidates under OBC A category was available, there cannot be any 4th, 5th or 6th phase counselling. Now the School Service Commission said before the honorable single judge, they will include the vacancy in subsequent counselling, 4th, 5th and 6th, because the rule does not say that I have to include the vacancy in the 2nd or 3rd phase counselling. My specific case was, there cannot be any 3rd, 4th or 5th phase counselling only because there is no left out candidates. This was my specific case. There cannot
There cannot be.
There cannot be any 4th, 5th or 6th phase counselling because there was no left out candidates for calling in
your
the counselling
category. Under your category.
under my category. There may be 4th phase, 5th phase counselling in respect to another category, another subject.
So these 4 vacancies are for
Yes,
OBCA.
yes, still remain unfilled in the. They have already conducted up to 6th phase counselling. Not a single candidate was called for this category because there is no other candidates after me, after us. That was my specifics. They should have included this vacancy in the 3rd phase of counselling, only to accommodate us, only to give the opportunity to those candidates. This was my specifics. That was not considered.
So the rule.
Yes, my lord. Kindly see the rules. My lord, page 76.
Dr. Patro, we have fixed an identical matter.
Yes, yes, on 21st.
21st.
Yes.
Today's 18th, my lord.
21st is Thursday.
Mr. Badi, come on 20.
My lord.
We have a identical matter.
My lord, I will come on that.
Only difference is I am the appellant in that matter.
Right. We will be considering the ambit of 17.5.
Yes.
And
My lord.
did you
That
get
matter
the
related to HM, headmaster, headmistress recruitment.
Maybe the process is same.
The principle
process is this?
absolutely the same.
So if we allow this, we will allow that also, or dismiss this, dismiss
Yes.
that.
My lord. 21st, my lord.
21st.
I am for the appellant, man. Affidavit of service, man.
Lordship, Mr. Rai Mukherjee is appearing for the Paschim Bongo Sarva Shikha Mission. I'm praying
Ask
for a
him to
short
come.
Passover, Your Lordship.
Ask him to come.
I have asked him to come. He's on his legs. He's coming, Your Lordship.
The
There is a delay.
there was a
Delay
delay,
of how many days?
18 days, man. 18 days.
1 8. Where is the order impugned?
In the name of appeal, my lord. 7th March of 2020.
ওরে বাবা,
man.
তো বিরাট order দিয়েছে। 7th March.
Man.
It was hard on affidavits.
Arson affidavit.
Huh?
Man.
Where are the, have you enclosed the affidavits?
No,
Then
That affidavit was not annexed in this stay application, my lord.
not evident. Oh,
Annexed.
Annexed, my lord.
not enclosed in your
Yes, yes.
Affidavit, I am not annexed, my lord.
any scope of interim order.
No, no.
There is no.
But,
Will you file a paper book? We will.
No, no,
Huh?
But kindly give me a supplementary. I may be leave, my lord, to file the supplementary affidavit, my lord.
Opposition reply you have not annexed.
No, no, my lord. I am not annexed, man. I am not annexed, man.
The appellant pressed for leave to file a supplementary affidavit. Stop.
দাদা একটু সাপ্লিমেন্টারিটা দিয়ে দেন।
I am for the appellant. My lord, there was a direction for completion of exchange of affidavits. My lord, they have served that affidavit in opposition. My reply is ready. And I have not yet affirmed it. My client is coming. My lord, kindly text it up tomorrow or my lord, any day convenient.
Next Monday,
Lordship.
next Monday. Yes.
I am for the respondent writ petitioner.
My lord, the learned advocate Suman Sengupta is arguing in this matter has not come to the court. My lord, I'm paying
Sir,
for an
how many
accommodation.
times we will adjourn? It was called on the last occasion also. If you don't want to do, don't mention the matter. It is frustrating sometimes. Every matter, if we have to accommodate, and all advocates are on legs. Surprising. What is the matter about?
The petitioner is praying for higher pay scale. Already, my lord, there is a larger bench judgment, and my lord, the petitioner already obtained one order from this honorable court. The petitioner has not filed a contempt. Thereafter, my lord, for the second time, my lord, the writ petitioner approached the writ court. In the meantime, the larger bench also passed order that if at the point of time when I joined,
Larger bench means
three judges bench, the reference higher pay scale, this one, my lord. Last occasion, I didn't had this order, this judgment.
This was authored by
Justice Oris Tendon, Somensen and Kaushik Chandra.
when was it passed?
My lord, it was passed on 7th February 2024. Larger bench, my lord.
Whether it is covered by that or not, that is the
It is covered, my lord. According to me, it is covered. And my lord,
they are assailing that.
yes, they are assailing. And another, my lord, I have already got an order from the single bench before. And since the order was complied with, and in respect of me, it was not complied. So this is my second writ petition.
Next Monday,
Well, next Monday, I will have some difficulty, my lord.
next Thursday week. Thursday week, yes. 28 তারিখ. Yes, next.
Or I am for the appellants, ma'am. Mr. Kollol Bosch is appearing for the writ petitioner, respondent number 1. On last occasion, my lord, for my difficulty, it was adjourned. In presence of Mr. Bosch, my lord, I am not getting Mr. Bosch now.
What is the matter about?
Or the appellant before lordship is the institute.
For hearing, appeal hearing.
No. It's for the first time.
First time.
Gonikhan Chaudhary Institute, my lord, it's a institute, central government funded institution. And the writ petitioner, he was one of our faculty member. My lord, at a later stage, it was found that he was lacking minimum qualification to the extent of experience which was required. The law says 8 years experience is compulsory. Out of 8, 2 must be postgraduate, post-PhD. He had 4 years post-PhD admitted. Regarding rest 4 years, there was a confusion. Our contention was there in terms of law, the experience doesn't mean experience against any post. There must be some parameters.
Requirement was 8 years experience.
8-year experience.
2 should be post-masters.
No, yes, 2 should be post-PhD.
Post-PhD.
Now he had 4 years post-PhD.
6 would be on the.
At least 2 post-PhD.
Now he had 4.
4. So there is no problem regarding 4. The rest 4, we say he didn't have.
Why do you say so?
Because the experience must, my lord, it's qualify certain guidelines, certain parameters. Experience as a primary school teacher will not make him eligible to be appointed as an assistant professor in physics. That guideline is, AICT guideline is there.
So now where he is working?
No, he has already been terminated by us.
Oh, he has been terminated for lack of experience.
Lack of experience. Now,
against that,
he filed his writ petition. Yes. Now, when the writ petition was disposed of, certain thing was taken into consideration by the court. Court was pleased to set aside the termination, directed for his reinstatement with all back wages, direction for inquiry against the institution to ascertain whether the institution in the safe hand of the director, while the director has already retired prior to disposal of this writ petition. And third thing, the court is also in confusion whether the writ petitioner had the requisite qualification or not. That's why the court was pleased to direct the UGC, chairman of UGC, to form an impartial committee and to ascertain whether the petitioner at all had that, my lord, experience or not. These are the fourfold, my lord, directions passed in the writ petition.
UGC was a party to
Yes,
this?
yes, yes, UGC is a party to your lordship.
Then
Yeah.
have they taken any decision?
No, no. Now, I beseech your lordship one thing.
Are you aggrieved by delegation to UGC?
No,
No.
no. My first grievance that why should there be,
Then we will consider after the UGC opinion comes.
well, let there be direction upon the UGC to,
Who appears for
My lord,
UGC?
kindly, my lord, I respect his understanding of the facts, my lord. Kindly, my lord, kindly, my lord, take pain, my lord, to go through the order under appeal, my lord.
We will go through it, but what is
No,
your...
the narratives, my lord.
You didn't prefer appeal against relegation to UGC for
No,
consideration.
I mentioned this matter before the honorable single judge says that instead of UGC, it should be AICT. The learned single judge says it's a kind of a review, come up with an application because he vehemently opposed to such prayer. I said the advertisement says that the entire appointment procedure.
Then
should
what
be-
happened to the review?
No, I did not file any review. I said in place of UGC, it should be ICT because advertisement said because it is ICT affiliated.
No,
So it
did
should
you file any application?
No, my lord, no, I did not. I mentioned that
That
for
was your
correction.
submission.
That
in
my
the-
submission, and it was the honorable single judge recorded an order that I should come up with a review application because it needs a hearing. So I said, my lord, this is an error apparent on the face of because it's a mistake on the part of the court. In place of UGC, because advertisement says in no uncertain terms, my lord, the appointment procedure would be guided by the ICT regulations. Now his interpretation was no, that is the correct interpretation. It should be UGC.
AICT is a party.
Yes. Now the AICT guideline says,
Be that as it may, my lord, your lordship kindly, my lord, takes pain, my lord, to turn, my lord, to the order. My lord, what is the point? He has said different thing.
We are not on that. There is a direction for constitution of a committee for consideration, whether it will be by UGC or AICT, that is the dispute.
Right.
So we will hear you on the limit because you did not prefer any
No,
appeal.
I did
against
not
the
prefer any appeal, but I oppose this appeal on this court. Milord, a service rendered by the petitioner as a probationer, Milord, he has completed.
Mr. Bose, we are going on to the other side of the issue. Suppose today, let us understand there is a relegation for consideration of an issue. You say that yes, I am not agreed by it, but the authority should be AICT.
Right. Milord, there are 4 issues, he said.
Very good. If AICT conducts, do you have any objection?
no, let them conduct.
Very
Let them conduct.
AICT.
Let
Yes.
them
Milord, let him place the appeal, Milord. Why he should be entitled to get stay? Otherwise, Milord, I am out of employment, Milord, for the last 2 years. I cannot withstand the sufferings.
You have been reinstated subject
No, because
to
they will not implement the order because of the pendency of the appeal. I could not file a contempt. Because of the
No,
because
let us understand when were you terminated?
Milord, that is way back in 2023,
Now
2024.
the single judge said reinstatement.
Yes.
Subject
No. 4 different directions. One, inquiry against the director as well as the managing committee, governing body, when the director is no more there. Second, reinstate him with the back wages. Third, form a committee and inquire whether he is at all eligible for the post.
So it becomes your contention, it is self-contradictory directions.
Yes.
No, question is got the employment, I was directed to be reinstated. Now, my lord, the termination of a service of a probationer, my lord, that is a stigmatic termination. The law is well settled since 1993. That, my lord, if it is foundation and motive, the Honorable Single Judge, my lord, relied on this fact that there is the termination order, my lord. Kindly cease. Inquiry part is a different aspect.
No, it's
Even
not.
if
It's not a different aspect.
inquiry, suppose the court holds, the division bench holds, my lord, that the inquiry is not at all required. But the other points, my lord, if I survive on the other
The
points,
learned single judge, the first direction is to reinstate you with
yes,
back wages.
yes,
The third direction is UGC conduct an inquiry to see whether you had the eligibility to be appointed. So how can the reinstatement take place
kindly
prior
see
to
what
the
is the
order,
language, my
the
lord,
inquiry?
because, my lord, because the stigmatic termination itself, my lord, stigmatic termination of a probationer without holding any inquiry, my lord, it is sufficient for the writ court, my lord, to pass an order for reinstatement.
Had you have the appropriate
The
qualification,
eligibility criteria.
eligibility
Question is, my
criteria.
lord, what is the reasoning that weighed with the single judge? Kindly go through it, my lord, that is
Mr.
reasoning is there.
Let us understand.
Yes, kindly,
Kindly come to internal page 30 of the judgment.
13.
30.
30.
Yes.
Please read para 44.
There can be no automatic presumption that merely by virtue of a holding a high.
Paragraph 44.
44. Therefore, based on discussion reasons set forth in the foregoing paragraphs, I am of the considered view that the termination order dated such and such, whereby the petitioner's service were terminated, is unsustainable in law and liable to be set aside. Accordingly, the said termination order is set squashed. The petitioner's service shall be deemed confirmed from the date of expiry of the initial probational period. The petitioner shall be reinstated to his previous position with all consequential benefit, including back wages, continuity of service within 4 weeks from the date of receipt of a copy of this order. The Secretary, Ministry of...
No, now come to 46.
The chairman of the University Grants Commission shall appoint an expert of unquestionable integrity and impartiality who shall remain uninfluenced by any extraneous consideration in the discharge of duty. The appointed expert...
Yes, now the appointed expert shall conduct a preliminary inquiry to determine whether the petitioner met the eligibility criteria. So unless you prefer an appeal against this observation, setting aside of termination goes, it is self-contradictory direction.
Milord,
whichever way you go, Mr. Bose.
Question is, Milord, that before the inquiry committee...
Your contention, if we have understood, is that the probation non-confirmation itself was stigmatic. So that is a separate issue.
No, I am saying the termination order, if it is stigmatic, is bad.
Right.
Now, Milord,
you could have said, we would have appreciated that condition had there been no rider of the single judge that I am doubting your qualification, so I am relegating it for
because the doubt was also, Milord, that the mind of the authority, Milord, who had terminated my service, authority's mind was, Milord, clouded with such doubt. Now, Milord, that is
appeal against a part portion of this order.
Milord, I will. I understood.
No, you decide. If you say I will, then we will hear.
No, if I don't, Milord, kindly only one thing. That this particular aspect that disturbed your lordship's mind, this particular self-contradictory, I said, Milord, with humility, that if your lordships are with me, that the termination which is stigmatic in respect of a probationer, Milord, is unlawful, illegal. That is required to be set aside. If that is the law, it brings about certainty in law. Second part, that inquiry committee is to be constituted. They, Milord, sought for disciplinary action from the higher authority that charge sheet will be issued against me. They did not do so. That means no disciplinary proceeding was initiated against me.
You. Termination was bad.
That is so, Milord, unless and until, Milord, the disciplinary authority or the UGC or the EICT comes to a conclusion.
That, Mr. Bose. We will go into that, Mr. Bose, if we find your appeal against these observations subsist. Because if I am not qualified, my engagement,
that is, Milord, your lordship kindly have the charity to consider. If you said if he, question is if, Milord, that is the probability. Question is
if. Why you want it to be relegated, Mr.
Milord,
Bose?
this is the, if I page 46. The chairman of the University Grant Commission shall appoint an expert. The expert committee must come to a conclusion that my appointment is bad because, my lord, I was not qualified on the date of appointment. This is yet to be reached. Before you come to a conclusion, why should I be punished? Why there should be an infliction or punishment? Why? Before that means, my lord, this particular that it is not a question of trusting an institution. I am an individual. I am fighting against, my lord, the arbitrariness of.
You say, so your contention.
You have
if
not
we
come to a conclusion. There cannot be any assumption.
If we have understood you, you are saying, in fact, you are saying that you have there is question of relegation does not occasion because the probation was stigmatic. The probation has been set aside. My
You hold
confirmation.
inquiry. You hold inquiry. You come to a decision. Before you come to a decision, without decision, you will terminate. That is the Supreme Court's order. Even will a temporary appointment, Article 301(11) applies. Will kindly see the law.
That is your risk and prejudice. You want us to go into it, we will deliver our judgment. We are giving you a chance, asking you whether you will do it or not. If you say, no, you answered this question, then we will answer. Yes, start your hearing.
I shall prefer an appeal.
No, Mr. Bose, now we will not allow.
But, my lord, without disciplinary proceeding, and he has inflicted punishment, and
Ask you to reinstate him with a condition that whatever salary is given to him, till such inquiry is conducted, will be returned to him if it is, will be returned to the institute.
প্রমাণ হয় যে আপনি অযোগ্য, তাহলে
Will be returned to the institute.
That in respect of the current salary. In respect of current salary, not the back wages. Because you have been
I will
directed.
render my service and I will have to give it back.
Let me complete. We have
Mr. Bose is excited.
my lord, we have been directed to reinstate him
It is absurdity.
with a direction to clear the back wages. And if your lordships directs us during pendency of this appeal, my lord, reinstate him, and he will get the salary that should be current salary. And if ultimately, my lord, we loses your lordship holds against us, then we shall clear the back wages. Because
Back wages is for 1 year, no?
No.
24 termination.
20 January 24.
Yes.
January 24.
So he entered when?
2019. So back wages for at least, my lord,
We want what is weird, prima facie, what my brother and myself. The thing is, we will consider your argument that segregate two things. If my probation is ab initio void, you have to reinstate me. This is one aspect of it. But at the same time, there is an issue of relegation, which you are saying that today, why should I be at the mercy of when the relegation will be gone? Suppose it takes 10 years. So it is for you to decide. We are not.
No, I have taken instruction from my client. We will file appeal, my lord, on Friday, subject to the availability of certified copy to that portion, my lord, the delegation. Yes.
Not no instruction of client. What do you say? This is a good point you are arguing. We will decide it.
No, I said, my lord, that disciplinary proceeding, the authority said they will hold inquiry. They stopped their journey there. They did not do so. They, my lord, issued a termination order, making certain allegations because, my lord, I have, my lord, wounded the ego of director's wife by reason of, my lord, certain communications. What is that? No vulgarity, my lord. Just I say, my lord, that institution is suffering from, my lord, certain illness. like every other institution. So, my lord, she took it personally. Now, my lord, what happened, as a sequel thereto, my lord, the three different show causes were issued to my client. I had to answer, my lord, within 24 hours. They always, my lord, wanted a knee-jerk reaction from an employee, my lord, although they are a role model employer. And this kind of attitude, my lord,
you reinstate him and give him the current salary, subject to a condition that if ultimately you succeed.
Yes, ma'am. But my lord, I will be praying for stay of two things. My lord, kindly come to paragraph 45 of the order. The Secretary, Ministry of Education is directed to appoint a person of impeccable integrity and impartiality to conduct an inquiry into the overall functioning of the institution. The appointed individual shall remain uninfluenced by the presumption that the action of high-ranking so-and-so, including the director, assistant registrar. Now, the object of inquiry shall to determine whether under the leadership of the present director. Now, the present director, my lord, he already retired prior to disposal of the writ petition.
Very good. We will consider
In the month of July 2024, he retired.
Now, you reinstate him. You reinstate him. That inquiry and
Yes.
that we will hear your argument.
This inquiry, which has been conducted, which has been directed against us, since the director is no more.
And what is the other thing, Mr. Jahan, that you're what?
This is one, and let there be a stay regarding, my lord, payment of back wages. And third thing, my lord, if it suits your lordship, let a report be come from the UGC or AICT regarding the clarification of his, my lord, qualification. Why he is shy about his qualification? Because if it's come in his favor, we shall not stand.
No,
We shall not stand.
The report is the consequence of an inquiry which is to be conducted.
Yes.
The mode of the inquiry is also to give him a reasonable opportunity of hearing.
Yes.
So then you're practically implementing the order.
No, this is separate thing, because ultimately, my lord, there is definitely a doubt about qualification, and that is
we don't know. You've created
that is in the mind of the court, single judge, as well as, my lord, that was our point. Only point that. Now let that be clarified by the authority.
No,
because AICT or UGC, they are the highest body. They can say whether this is an appropriate qualification or not.
I will come up with the appeal, my lord, memorandum of appeal, my lord.
Why my learned friend is shy about his qualification?
It is not my shyness.
No, it is not that, because he has been selected by you.
Millard, only I am extremely
appointed
grateful.
him.
Millard, the inquiry,
Yes,
the selection
you were allowed
committee,
by his, my lord,
Millard,
affidavit.
Millard, what he has not uttered, Millard, his silence has some meanings. Millard, the selection committee was constituted by the National Institute of Technology Patna, one of the most premier institutions of this country. All experts from the IIT. Millard, they selected me. Now, my lord, they wanted to sit as an appellate authority, so far as my selection is concerned, by way of interpreting my qualification. And that too, my lord, in the way that July 2022, when, my lord, there was certain compatibility conundrum. According to their own perception, the authority felt that I was the person, my lord, who, my lord, created groupism inside the college. As a result whereof, my lord, only because of the suspicion, they issued a first show cause notice, asking me to respond to this. My lord, no inquiry, nothing. The court had come to a definite finding with regard to the termination of and my lord, another thing, my lord, even if, my lord, the appellate, the contradiction, my lord, which the Honorable Division Bench has just now found, my lord, I bow down to that. Paragraph 45, 46, my lord, the inquiry part.
He
We
said,
understand, Mr. Bush, your argument we understand.
but he was appointed in terms of his claim regarding experience.
Then Mr.
We
Jha,
sent
we-
letter to those authority where he was working. Everybody says he doesn't qualify the parameters.
Absolutely.
That we have annexed, my lord. That was
Absolutely
the
not.
basis. That
Absolutely
is the
not.
basis.
এই ইউটিউব চলছে না?
অবশ্যই চলছে। অবশ্যই চলছে।
upon exchange of leave.
Yes.
You have brought that on.
Yes, everything. Affidavit, report, exception, everything is there.
Very good. We are keeping it on Thursday week. We will hear out the matter. He will file the
Yes,
appeal
ma'am.
in the meantime,
Yes.
which will be included along with this.
Extremely good.
সেটা খুব decide করে। What is happening? Appeal করবো limitation এর দিয়ে দেবে। Then you file the take steps. We will hear it on Thursday. We are not saying that you have to file. It is
No,
your.
it is out of my own volition. It is my decision, my choice.
You consider, Mr.
No, I will do it. I have understood. Milord, kindly, I am seeking one indulgence. It may not be possible for the department to provide me certified copy.
Leave,
Because
leave,
Huh?
leave
Yes,
chain.
I will seek leave from my lord. Leave to your best.
You pray for leave on Thursday.
Yes,
We will next Thursday week করে দাও।
Great.
Thursday week.
Thursday week এ না ওই যদি একটা অ্যাপিল ফাইল
My lord, I am for the writ petitioner respondent. My lord,
No,
this was-
I am for the, let him not, my lord, be so vocal because it is my appeal. Second one. This is an appeal, my lord, where
what you are asking?
No, I am for the writ petitioner respondent.
Oh,
my lord, Mr. Ujjwal Rai probably, my lord, addressed your lordship by saying that Monday he phoned me, my lord. He told me that I will not be available. Kindly
There are
bear
two appeals, my lord.
Yes,
One
yes.
by the respondent, one by the school. Let school proceed with
School appeal. Ujjwal Rai is the respondent.
when have we kept it?
My lord, last
He
occasion
wanted
also.
to be kept on Thursday.
Huh?
He wanted this Thursday because he is out of station. He probably, my lord, told your lordship for that. He very said that I have addressed your lordship.
Which is that matter?
Both the matter, 7 and 8.
Oh, 7.
8 is the appellant. Mr. Bhattacharya is the appellant.
Yes, I am the appellant. He is the respondent. Against the same order.
Mr. Dasgupta, then we have to hear you again adjourn for him. So we keep it on Thursday. We will take both the
My lord.
matters. Yes, Thursday.
That-
Thursday রেখে দাও। Yes, next. Passover. হ্যাঁ, কোথায় ছিলে? Passover, you are there? Yes. Who is your other side?
Lord, Mr. Bosu Mollik is there. I was only proposing this. Shall I inform him? My lord may take up tomorrow in his presence.
Not today. কালকে একটা কি ফিক্সড আছে না?
আমাকে wrongfully কিন্তু একটা
David service, my lord.
My lord, petitioner has served the copy wrongfully to me. It was supposed, copy of the application was wrongfully served to me by the petitioner. My lord, please direct the petitioner to serve the copy to government pleader office in proper channel.
You are appearing for this state.
Actually, in erstwhile earlier matter, he was appearing in that.
That matter is already disposed of, my lord.
You have to serve the government.
Yes.
pleaders.
My lord,
Kindly keep it on next, my lord, Monday.
Next Monday, yes. Next.
deeply obliged, my lord.
Order হবে?
হলো না
Order will
appearance.
pass to us.
Yes.
I made an appearance today.
Today.
But we cannot record his appearance then. He is not engaged, na?
My lord, you can record her name. I
Direct
might
He
not be there. That is not an issue, my lord.
allegation is against whom?
Board is a answering response. মানে
Answer script.
no disciplinary proceeding concluded. He is challenging the suspension.
Board is, malab, during pendency of the matter, board has issued a letter for compulsory retirement, my lord. By
Compulsory retirement of
Impugned order, your lordship.
No, but there is a defect in the appeal. You have not impleted 8 and 9. Huh? There is a defect in the appeal.
my lord, because
There is a defect in the appeal.
defect in the appeal.
Eight and 9 করতে কে বলে?
because my lord, this is not a final order, but situation is this.
বোঝাতে পারছি না। এটা দেখ।
Yes, sir.
ডিফেক্ট নোট দিয়েছে সেটা ক্লিয়ার করতে হবে দেখিনি।
Oh, second judge's paper not filed. Name not find place in.
There was no 8 and 9 in the writ petition.
Oh yes.
Who are the respondents 8 and 9?
Even in the school.
So why haven't you impleted them? Have you impleted them in the appeal?
No, my lord, probably not. Actually, board is a.
Actually, whoever it is, you will, as per your choice, you will implement or what? Lekho, the learned advocate appearing for the Send it to the single judge.
My lord, actually, I tender my apology.
Don't understand the subject. You go on, my lord, come to 255, 350. We are trying to help you. You are going on.
Actually, I am aggrieved by the order. Why? I'm answering.
May I
Wait, Miss
examine the matter? What is the matter?
Wait. In your stay application, where do you have annexed this order? The order to challenge petition.
Page 258.
Order text. Supposed to do it. ও সেকেন্ড শোকজটা স্টেজে এখানে এসছে Yes, Mr. Ram.
My lord, when the matter is pending before the Honorable High Court at Calcutta, whatever is wrong or right, everything is going on. In the meantime, the board has issued a compulsory retirement against. That is at page 260.
That is the second showcase notice given to you.
It's a punishment.
What is the proposed punishment that has been said?
Proposed punishment, my lord, how it is, my lord, tenable? Why I am telling you, lordship? Because they are playing with one side.
Achha, kindly
Without hearing me, since the matter is pending before the Honorable High Court at Calcutta, I cannot participate in their my lord, hearing. Because since the matter is pending before the Honorable High Court at Calcutta. So without taking a leave, so board is acting more than a High Court here. Page
have you amended the
Yes.
petition?
Yes.
You amended
Yes.
the
Yes.
What prayer did you include?
But to revoke the suspension order. Because from the very beginning, my lord, Honorable learned.
Page 260,
Yes.
the 31st July.
Yes.
This was not there before the learned single judge when the matter was last taken
Yes,
up.
after passing of this order, they have issued that. The order was passed on 27th
That
of
is exactly
July.
what I'm saying.
Yes, madam.
Please understand.
Yes.
This was not there when the matter was last taken up by the learned single judge.
Yes, madam.
On 23rd of July.
Yes.
You are going to ask for a stay of this order.
Yes.
in the appeal. Should you not approach the learned single judge seeking a stay on this? Or to include it in your supplementary affidavit? This was not before the learned court.
No, my lord, that is afterthought. What actually, the order was passed on 27th of July.
Please come to.
The order passed on 27th of July. Now they have issued 31st of July.
Aftershock. We are also feeling the aftershock.
You immediately make amendment in the writ petition challenging this order and pray for an interim order. Otherwise, we cannot help you because your challenge in the writ petition was challenging an order of suspension. Very
Yes.
good.
Lord.
So when the court matter appeared, there was direction for evidence.
Yes.
Against that, you went to appeal court. Appeal court said that no, he has challenged the suspension, but now this is the situation. We grant him leave to amend the writ petition.
Grateful, Lord.
But when you amended the writ petition, this order was not. Did you amend at all? You did not amend.
Yes, my lord. I have already filed.
Mr. Ahmed, now kindly listen. After that order was passed on 21st of April 25. Now they issued the final order on 31st July 2020.
Yes, my lord.
So I think for that reason, you wanted to bring that on record. As such, you prayed for, allow me to file a supplementary evidence. Court granted you that leave. Now this stay of by this order, you have been compulsorily retired. Right?
Lost.
Compulsory. So if that becomes the subject matter of the writ petition, you can challenge that order also before the writ court. You should have filed an amendment application because in the midst thereof, this final order has been passed. Today, if we stay the order, what we will hear? Before us, it has to go to the first forum. You follow?
Yes, Lord.
That's how writ petition. Where is the writ petition? What amendment you made?
No, actually, writ petition's copy is not here, my lord. So, my lord,
And no amendment. If
amendment
made, that might not serve.
Can 3 was the amendment. I have already filed. Can 3.
Amended by
Can 3 in this
in the writ petition.
The learned single judge.
Yes, ma'am.
Oh, achha, so very good.
Can 3 is the writ.
Oh, you have filed Can 3?
Yes, my lord.
Now, Can 3, you enclose this order of 31st July?
No. Because during that time, that order was not issued to me. After passing of the learned single judge, this order was issued.
My lord, this final show cause
So, my lord,
was issued prior to hearing of the this matter by the single judge. My lord, final show cause was issued on 25th July 2025.
No, my lord, when my lord,
The impugned order passed by the learned single judge on 23rd July. My lord. Well, all this matter was before his lordship.
Proposed order.
When the matter is pending before the High Court, my lord, how dared they file such
There was no
compulsory return, my lord? Because I did not participate since the matter is pending, my lord. But they are
So now what is the
single way
problem? He will challenge the
without
order
keeping
which you have
headmaster
passed
dark.
by amending the writ petition.
But he can always
main
challenge.
petition.
But when a final order of DP has been concluded, final order passed as per
So he has a right to challenge.
yes, before the appellate authority.
Pardon?
Now, before the appellate authority.
No,
Because final order
The
DP
appellate-
concluded, final order passed. So, my lord, now this challenge of show cause is invalid.
Madam, he was granted leave to amend the writ
But he
petition.
didn't do it.
So he didn't knew. He filed Can 3.
Yes.
When he filed Can 3, the final order did not come.
But my lord,
Lordship.
show cause was there.
Very good. Now there was no stay. You have
No,
proceeded.
yes.
You have passed the final order.
Yes.
So somebody has to test the veracity of the 31st July order. Your contention will be go and file an appeal. And his contention is no, it is an ab initio void order. You decided in the writ petition. So we will grant him leave.
To be heard by single judge.
He will grant
Lordship,
supplementary affidavit will not help you, Mr. Ahmed.
Because supplementary, why help? Why sir not helping my lord me? Because they have said the subsequent development. Because subsequent development, my lord, I cannot participate since the matter is pending
So
before
where
the
is
High Court of
bar
Calcutta.
participating in?
But my lord, they are
Just tell
but they are
him
taking steps singly with the keeping
there is
headmaster.
bar in law, my lord. If he challenge
So-
the
So
suspension, and
subsequent
does-
development actually from their part, they may file subsequent development.
What?
But I don't have such a development because I do not take any step. I do not participate in their meeting. Since the matter is pending before the Honorable High Court at Calcutta. So singly they have taken against all kind of my lord, decision against me.
No, he is in.
Lordship, item number 10, I am for the appellant, Lordship. Lordship, I am compliant for the adjournment for the Lordship, 1 week, Lordship. I am so, Mr. Lordship, Jana Lordship, give me some 1 week time for Lordship.
Next Tuesday week. Yes, next.
Next Tuesday.
Next Tuesday, Lordship.
Tomorrow is a Tuesday.
Today is Monday, Lordship. Oh,
Upper Monday.
Sunday.
Today we are on Sunday.
oh Monday, Tuesday, Lordship. Tomorrow, Lordship.
This Tuesday you can
No,
do.
Lordship, that Lordship, I am still, Lordship.
So we have kept
Tuesday,
Tuesday week.
অনেক দিন Lordship, অন্য দিন।
Tuesday week. 26 তারিখ রেখে 26th. Yes, next.
That I appear on this great petitioner respondent.
Yes, sir, Lord. Deputy service. Your Lordship. The application, my lord.
336 দিনের ডিলে।
Well, there is a delay, my lord. Yes, my lord. 293.
336 days delay.
336.
অপোজ করুক। কম্পেশনেট অ্যাপয়েন্টমেন্ট কবে অর্ডার করতেছে?
না ওখানে
You are
লিখে
not
দিয়েছে
opposing section 5?
Yes, my lord, definitely.
Ashu, the present appeal has been preferred, challenging an order Mr. Ganguly, when it is fixed, your Supreme Court matter?
was in this September, sometimes in 19th or something like that, but I'll confirm with that.
Yes, next.
There is no stay of the impugned order, only stay of the content proceedings by the Supreme Court.
No, no,
I
in
have checked
the
up.
matters, there was a
That is
stay of
true.
the
That is
impugned
between
order.
Acharya. That's a different aspect.
No,
But on this impugned order,
No, we have passed an order, Mr. We have passed an order.
Justice Showman's division bench passed an order considering the university first statute and other things. The Honorable Supreme
No,
Court.
no, there are two things. One, in some cases, contempt state, in some cases, impugned order.
I have got all the orders.
Very
Only
good. You come
between
with that.
Chatterjee state. Otherwise, all others contempt.
You come with that. We have.
I
kept
have.
it
I
on
have all the
service.
orders.
But in
Yes.
four matters in appeal, already the impugned order has been stayed. Well, that's why I pointed out before your lordship. in the last
Please give him the reference.
I am giving you the chart.
Yes, next.
Lordship, I beg to appear on behalf of the Madrasa board, your lord. In the morning, I've been instructed to withdraw this matter by the board. If your lordship,
Withdraw the matter.
lordship,
You are the advocate on record.
no, your lordship, advocate on record, her father had expired, so she has not yet joined the court, your lordship. So I generally appear for the Madrasa board. So I've been instructed in the morning. So if your lordship pleases, so I can bring a written instruction.
We will record your name.
Your lordship,
Responsibility will be
I
yours.
generally appear on behalf of the Madrasa board.
Any written instruction you have?
If your lordship desires, so I can get the
desire?
Why should we
Bring
desire,
a-
sir?
I can, your lordship, in the tomorrow.
We want to see that you are not facing any embarrassment.
Lordship,
That is
lordship.
why we are saying. Otherwise,
Lordship.
কি আছে?
But lordship, I am I generally appear for the Madrasa board. But in any ways, I'll bring the instruction, written
appearing in this
instruction
matter?
tomorrow.
Are you appearing in this matter?
Yes, yes.
দেখি
I'm
ফাইলটা দাও তো। Day after tomorrow to be mentioned.
Your
Day
lordship.
after tomorrow.
Your lordship. I'm great.
What instruction he wants?
Just the written instruction.
What instruction my learned friend wants?
To withdraw, madam.
To withdraw. sir.
Withdraw.
Withdraw.
To withdraw.
Affidavit in opposition.
I could defend the honorable court. Let me keep the record.
Opposition to the section 5, na sir?
Next
Stay
file.
application.
Section 5A, section 5A.
You are for whom, Mr. Oh, Mr. Ali? You are appearing for writ petitioner, managing committee.
Not Ali, not your senior, leading me, Lord.
Biswajit order. Status quo with regard to this one, sir. লেখো ওনার নামটা, এফিডেভিট না, রিপ্লাই তো ফাইল করেনি।
We are grateful. But I'm for that.
I appear for NCT in the matter. Lordship, from record it will appear, it will appear. Lordship, from the last order, I was given direction to file an affidavit with certain
19th of
comprehensive
May.
directions. Lordship will kindly see. So, Lordship, I seek some time, more time, Lordship.
How long will it take, madam?
Lordship kindly sees the direction. Lordship, they have to take records, check records of the whole country. They have to check records of the whole country because the direction says that whether this kind of application was allowed or not.
Direction
Then
dated
you should have
19th of
taken appropriate steps.
Lordship, they are searching, I'm told. Every day I'm asking them.
You have not preferred appeal against that direction.
No, we are not affected adversely by that order. Just only thing, we need certain time to comply with that. Lordship, I'm told that mostly they have completed the inspection, all that. So in 4 weeks, Lordship, I will be able to file.
4 weeks?
Because they will give me instructions, I will give them affidavit in Delhi and they will affirm and send it to me. At the outer limit, Lordship, 4 weeks only. I will not seek further extension. In all fairness, Lordship, because the directions are
What is the matter about?
Murder, the institution is before Lordship. They have prayed for an opportunity to upgrade from our basic training to B.Ed, that course. Now the authority says we have already closed the portal. We cannot allow anybody to make any online application, and there is no provision
For
for
commencing the B.Ed course.
and there is no provision for any offline application. Law says every year there must be, my lord, applications during a certain period, and that would be kept open. But, my lord, they themselves.
That has to be online.
Yes.
But there was no portal to that effect.
Portal was there, and the portal is not allowing anybody to, my lord, make any application.
May I, Lordship? Because as per 2014 NCT regulations, everything to make transparent is done online. And Lordship, after a certain time, because there was National Education Policy 2020, and there were efforts to upgrade and reshape the regulations, Lordship, as per the Vaishno Devi order of Honorable Supreme Court, Lordship. So all over the country, they stopped online applications. So the institute is running a course. They want to make it at par with composite institution. So that was not allowed in 2015 or 16. They came to court in 2024. But still their writ petition, after the rejection of the writ petition, they went into appeal, Lordship. And I took that point.
Learned judge say.
My lord, kindly have a look, 19th of May. The order passed in this appeal. An order passed in this appeal
these are-
19th of May.
Read
Madam, you are appearing for whom?
NCTE. The
Yes,
authority
there is
regulate
an opposition file. What is this?
that was to the writ petition, I believe, or to the appeal by the prior council.
Now, my lord, ultimately on 19th of May
Lordship, the writ
2025, the earlier
petition is
division bench
rejected.
directed
Yes, we shall come back to you. Yes, let us understand. But it is their contention that they had not done so since 1920 to
Now, my lord,
2019 to
the
20.
rule doesn't say that they have to invite any application. Rule doesn't say the state has.
The grievance was that as online submission has been stopped,
Yes,
my grievance is not being redressed. I am not being
I
able to-
cannot make any application.
So very good. If over, we understand that the judge said that when the portal opens, you will get it.
No, no, how could they stop the portal?
No, we
Yes,
are asking you,
yes,
Mr.
yes.
Jahan. This you were never a B.Ed institution.
No, no.
You were running a course of IT.
DLED, DLED.
DLED, very good. Now, if all over West Bengal, this is the this is the what should I say, fact scenario, then
Now the question is that 2014
your
to,
question is how long I will wait?
but that's the reason they were kindly have a look 19th May order, which has been passed in this appeal.
No, we understand, but
Let them
they are not.
say whether they have already suspended this 2014. They also
They
did
have not put
bring
this bigger
response.
question in a public
They didn't
interest.
respond.
They are putting this question now. They have not put
We
that
are
question.
why public interest? We are affected by the same.
They will not follow my regulations.
No, he is saying that I would be following their regulation. Why this online application has been stopped? I am
This is
not being.
administrative decision. And we have explained number of times to so many institutes. He is coming after so many years. Even in appeal, there is Section 5 application that is not allowed till date, if I'm not wrong.
I believe that has been
And
allowed.
no,
It has been allowed. It has been allowed. 45 days delay, it was allowed.
then it might be.
Yes, on 29th of November 2022.
In any event,
Order dated.
they are asking for their application, and that, as rightly said by the Honorable Single Judge, and that is the correct position. Anybody can apply when it is open, and it is opened up for everyone.
No, the court wanted to know that why you have stopped that.
Yes, yes, Lordship, I explained that. I'm ready to explain that further with the documents.
Heard Mr. Jahan, learned advocate, appearing for
Online is allowed. It sometimes some online is helpful. Sometimes, Lordship, we are aging, so online submissions are, if allowed, Lordship, that helps a lot.
Sorry, madam, you may be having a point of view. It becomes very difficult for us to hear you online because there is wavering. What comes to us is after a fraction of a second, and what is told to us, what we say, it goes to you at fraction of
It
second.
happens, Lordship. It happens.
And we are dealing with thousands of matters.
Lordship,
Sometimes it
Lordship.
becomes inconvenient.
It cannot equal. The experience is totally downgraded comparing to physical appearance. That is true.
Yes.
Grateful, Lordship.
14, my lord, I am for the petitioner. My lord, this is my affidavit of service, my lord. I am led by Mr. Nilanjan Bhattacharya, learned senior advocate, lordship.
কোনটা ওইটাই কি ও is it that application that person expired?
No, my lord. Organizing petitioner has been retired, lordship.
এটা অন্য ও আচ্ছা
1 year back. My lord, there is a delay of 78 days, my lord. Section 5. Have you section 5?
কিছু নেই রেগুলারাইজেশন
My lord. Section 5 now. Objection now. If your lordship dispose it of, you can, lordship.
you cannot dispose, we have to dismiss.
Thank you.
Tell us something about the facts.
The petitioner was joined as organizing teacher in the year 1994, 1st October, lordship. My lord, appointment letter in page number 72.
Respondent state. State with both.
Where is this 21st June letter? 21st June. Do you have that? Oh, that is the page 101.
Lordship.
The present appeal has been preferred.
Number 15, my lord.
Respondent applicant.
My lord, I am appearing for the applicant here, my lord. My lord, my case is that issue
Before my
is
learned friend starts with this appeal is not perhaps correctly filed because the
my lord, it is my appeal, my lord. It is my
sir, kindly hear me. Already they knew that the daughter is dead.
Mr. Bhattacharya, let him finish up.
Well, okay, lordship.
Yes.
My lord, issue is this, my lord. It is the refixation of the pension and other retirement benefit of the for the period of, my lord, 11 September 1994 to 31st August 1978, my lord. My lord, my lord,
31st
refixation of the, my lord, pension and other retirement benefits for the period of 11/9/74 to 31st August 1978.
4 years.
4 years, my lord. My lord, in one word, my lord, my case is that yes, my lord, refixation of pay, my lord. My lord, initially, my lord.
Who are you?
My lord, I am state, my lord.
Oh, this is state, sir.
State's appeal, my lord. My lord, initially, my lord, my submission is this, my lord, to get back the, my lord, CPA, my lord, portion and, my lord, other benefit, my lord, he has to deposit the CPF amount, my lord. Otherwise, he cannot claim. My lord, circular is there, I will place it, my lord.
There is a section 5 here.
Yes, my lord. My lord, due to corona, my lord, we state could not was not in a position to file, my lord, appeal, my lord, and my lord.
Order was passed in 2018.
Yes, my lord.
You are challenging that order in 2025.
No, my lord. 26/6/2023.
Order impugned.
Order impugned, my lord. 17th July 2018.
No, there are defects in the appeal.
12th July. 17th July. 12th July.
12th July, my lord.
2018.
2018. 12th July. 12th July 2018, my lord.
Have you removed the defects, Mr. না ডিলে না পিছিয়েছে কি বলছে এখানে 1768 days delay. First title is stated. You have added a dead person.
My lord, ওনার মেয়ে তো মারা গেছে, ওনার মেয়েকে কি রেসপন্ডেন্ট করা হয়েছে?
ওটার জায়গায়
It was not within.
Application was allowed in the writ petition.
My lord, petitioner
allowed, Mr. Bhattacharya.
My lord, at the time of filing appeal, my lord, there was no knowledge on behalf of us, my lord.
Incorrect statement.
একটুখানি দেখুন না।
জজ সাহেবকে অর্ডারটা একটু দেখাবেন। It is their submission in the contempt proceeding that the daughter is dead.
Contempt সেটা কবে?
Thereafter you preferred this appeal.
No.
Contempt is the date?
Of course. Contempt is of 2020. Appeal is of 2023.
At the date of hearing, we mentioned, my lord. I'm asking myself, my lord.
12th of May 2023.
12th of May.
23. And this appeal, when did you file it?
Appeal has been preferred in June 23.
June 23. My lord, it is our fault, my lord. We will correct this, my lord. Fault.
Now, Nirmalendu expired. Thereafter, again, Aditi expired.
Lordship. Now, in the contempt, my lord, the brother and the sister filed the contempt.
Now, you tell us what is the.
My lord, may I submit, my lord?
Now, brother and sister means Aditi has expired.
Aditi expired during COVID 2020.
I see.
Contempt was filed in 2020 prior thereto, before her demise. Now, my lord, while the contempt proceeding was pending, it's a transferred brief to me. When it came to me in 2021, my lord, thereafter we found that the order was passed on a wrong notion by the earlier advocate.
So, Mr. Bhattacharya, that is the merits of the matter.
No,
Now
that is
we
correct.
are.
That is correct.
How we can entertain this appeal now unless you
Also,
correct
my
it?
lord, my lord, we will correct this, my lord.
কি করে correct করবে? You have not filed any substitution application. How will you? And moreover that, if you are wanting recalling, you wanted Mr. Bhattacharya's client wanted recalling of the order.
Yes, my lord.
That is 18th of July.
12th July
12th
2018.
July.
12 July
Now,
2018.
we are not being able to understand this when he himself wants the order to be recalled. You being the state, how you are agreed by such grant of leave?
No, my lord. No difficulty, my lord. There should
Then
not
if
be
there
any
is no difficulty,
No, my lord.
then you are not opposing recall.
No, my lord.
You said you are not opposing the recalling.
My lord, one thing, my lord, my learned junior is requesting me to
Yes,
submit
tell
before your
us what
lordship.
your
That,
junior
my lord,
wants to say.
no, my lord, it is our submission.
12th of July 2018, an order has
My
been
lord,
passed.
we filed appeal prior to filing of recalling application. We filed this appeal prior to filing of the recalling application by the petitioner, my lord.
Very good. Now he himself says that I am not satisfied with this order. This order has to be recalled.
Yes, my lord.
So we will record Mr. Bhattacharya's submission and dismiss your appeal.
My lord, then, my lord, kindly give us liberty, my lord, to withdraw the appeal in the submission adopted by him. What submission has adopted by him, my lord, we heard this code in open court, and thereafter we, my lord, we are withdrawing this appeal, my lord.
How hard this open court?
Application has already been
My
filed.
lord, this is state's appeal. May I pray for one indulgence, my lord? My lord, state is our client, my lord. We have to take instruction. Kindly record his submission, and my lord, kindly direct me to take instruction. I will come back, my lord, within 7 days, my lord. Possibly, state will agree, my lord.
Tell us what is the.
Otherwise, my lord, onus will come upon advocates, my lord.
Now let us understand the matter. What he is submitting.
My lord, this appeal has
So far appeals facts is
We will
concerned.
come to the, if we find his argument is not acceptable, we will return.
I'm grateful, my lord.
My lord, while the contempt proceeding was going on, the court passed
Which order contempt?
12/7/2018. The
What
order
did-
under appeal,
What order has been passed there?
allowing my writ petition on a wrong notion. Suppose today,
What was the benefit given to? There will be an order in terms of prayer A.
Prayer A.
What is
That is
prayer A?
correct. What I am on is this.
To cancel the order dated 9 September 2016. Yes.
Lordship, kindly come to the internal page 2 of the impugned order.
That is at page?
My lord, impugned, in the memo of appeal, my lord, this impugned order is
In the stay application not.
Stay application.
81.
So now this when did Nirmolendu expire, Mr. Bhattacharya?
2019 February. 2019 February.
Acha, February 2019. He expired.
Lordship.
Now, did you prefer any application for substitution?
Because contempt was filed.
Oh, 12th. That is prior to that writ petition disposed of. Acha. What was the prayer A was allowed?
Lordship. Well, should I hand over the writ petition copy?
No, not required.
Lordship.
Now, what did the court say? Prayer A.
Prayer A. That is okay.
No, that is okay means what was prayer A?
Yes.
Prayer A was to set aside an order of 19 September. Where is that 19 September?
That is annexed in the writ petition, my lord.
One.
আপনার কপিটা দিন।
Page 69.
prayer 8 writ petitioners. My lord,
That we have got it. We have got it. Prayer day, prayer, page 69 is the order of the
9th September.
So 9th September order was set aside by the
Impliedly set aside. Impliedly set aside. Set aside what is not there, but impliedly by
prayer day is set aside.
Yes.
Why impliedly you are saying? Your prayer day, page 36, was to cancel the memo of 9th September
Yes,
2016.
Hmm. But in verbatim, my lord, in the impugned order that is not stated. The impugned order was set aside.
Yes. Allowed in terms of
Yes,
prayer,
yes.
that means set
Yes,
aside.
yes.
Now, very good. Now, that order was denying you that the government has been pleased to do the entries. '74 to '78 period was not treated as qualifying service.
No provident fund was given, and not qualified service was treated.
So your pension payment order was issued when?
No account number has been opened. That was the case of the petitioner.
No.
The contributory fund was not deducted from the salary of the petitioner under the law. That is not my duty. That is the duty of the employer.
When did you retire?
I retired on 30th June 93.
30th June
1993.
Now, what is this period? 74 to
From
70?
74 to 78, that your lordship will find in the impugned order, internal page 2, third paragraph. Regarding counting of period of service from 11/9/74 to 31st/8/78, for which the Accountant General West Bengal raised a question, he is requested to obtain a detailed clarification from this concerned institution why no CPF deduction was made during the sponsored period of the institution, and furnish the same to his department for consideration and taking action in the matter.
Very good. Then 12th July, then what happened?
Now, my lord, may I draw your lordship's kind attention to the order itself, why I prayed for recall.
No, no, not required. After this, what happened? February 2019, Nirmalendu died.
Died.
Prior to death, was any pension payment order issued in his favor?
No.
No. Achha. Then what happened?
So far concerned this. Now, since the applicant, the son,
who is the applicant who preferred contempt?
Both the sister and the
That is
brother.
Aditi and
Orijit, who is respondent.
My lord, pension payment order is there, my lord, page 42.
Mr. Chaudhary, we shall come back. So you Orijit and Aditi.
Aditi.
Orijit, Aditi. Achha, very good. Now Aditi, Orijit expired.
No, Aditi expired.
When?
In 2020.
Expired in 2020. Very good.
19th February 2020.
Achha, then Orijit filed a contempt of.
Both of them filed the contempt.
In the meantime, she expired.
She expired. Now that was recorded in the contempt proceeding.
Very good.
11/9/2020, sister expired, Aditi. 11/9/2020.
Very good. Then what happened?
Now that was recorded in the contempt proceeding. Now thereafter, contempt proceedings was heard out. Now, while the hearing was going on, I drawn attention before the learned judge that we want to recall this order for reasons stated in my.
That is only Orijit.
Only Orijit. Because prior there to Aditi expired.
Then what did the court say?
The application is pending. Now they were refusing to accept the service of CAN.
Contempt application was disposed of, my lord. Withdrawn as dismissed.
Contempt was disposed of, Mr. Bhattacharya.
Yes.
Yeah,
Yes.
Mr. Chaudhary, we shall come back to you. Yes.
I prayed.
We are trying to sort it out. Let us see whether it will.
I prayed after this deletion of name of Aditi was made in the contempt proceeding.
For expansion
of the name.
And that was recorded in the order?
Dated. That is dated. Passed by Honorable Justice Rajashree Bharadwaj, my lord. 14/8/2023.
In the contempt proceeding.
In the contempt proceeding.
Very good. Then?
Now that was recorded. The contempt while was on that day after expansion of the name, the hearing was going on. Then I said.
This 14th August order is not annexed to.
It is here with us, my lord.
Do you have a copy? No, ওটা দিয়ে দাও বলতে পারবে না।
My lord, I have another copy. I have another copy. This is the CAN wherein this annexure is made.
এটা ওনাকে ফের।
Last line.
14th August.
Lordship.
You don't have any other brother, sister?
No.
Only Orijit?
No issue even.
And widow of the deceased? Deceased?
No. Nobody. Only this Orijit is surviving.
Achha. So rectification done.
Done.
Then
liberty was given to me to take steps in accordance with law. In the contempt proceeding. After
the contempt was dismissed as withdrawn.
As withdrawn with liberty to take step in accordance with law.
Very good.
Because of the order, there is a defect. So, if I proceed with the contempt, then I would have been held in contempt, my lord, for pursuing the order passed in the writ petition. Because the order was not passed on a wrong notion and submission. This is my respectful submission that I can clarify if your lordship wants so.
So, where is your, on the recalling application you filed when?
I filed recalling application, my lord, CAN. On my lord, that copy is given there.
4th September 2023.
It was application filed on 4th September 2023.
Within a month, on 14th August 23, liberty was given. I filed immediately. Very hurriedly, it was filed.
Liberty was given on
14th August 2023.
14th, you filed it on 4th September 23.
Lordship.
Now, then what did the court say?
Now, since they are refusing to accept the service,
recalling application,
the service they are refusing to accept. That is on record. Now, ultimately, Honorable Justice J. Sengupta was pleased to direct them to accept the service by naming the learned council's name of the state. Now, thereafter, they received it.
Very good
Now,
then.
the hearing before the Honorable different single bench, my lord, matter was listed. Once it was taken up, but could not reach, my lord. And thereafter, during the pendency of this same, they mentioned this matter and get it listed. This appeal.
When was this appeal filed?
This appeal was filed on
26th June 2023. 26th June 2023.
26 June.
June. Prior to filing of recalling.
June 2023, memo of appeal was filed.
So, Mr. Bhattacharya, the order of 12th July 2018, you want to
praying for recall.
Recalling of that order and for passing a fresh order.
Fresh order, as prayed in my can. Because
So,
there are different.
12th of July order, in the meantime, they filed the appeal.
Lordship.
So, the recalling appeal.
Not in the meantime, after 5 years.
No, we are not saying. We will record that, we will record your statement that you have.
Lordship, kindly don't, my lord. That will influence my application.
What we are saying.
Lordship.
We will record your submission to the effect that you have filed a recalling application on the basis of the liberty granted by the court, and that recalling application is pending.
Lordship.
And you and we will say that in view thereof, Mr. Chaudhary says that he will not proceed with the appeal. So we will dismiss the appeal as withdrawn. And recalling application, you go and satisfy the court.
Correct.
And get the order.
Correct. Now, as on date, this is a very innocuous order, my lord, that would be innocuous prayer also by this state, that is okay. But the problem is, my lord, any order is passed herein in a defective appeal, read with, there is no explanation even in the section 5 application, for which I didn't file any opposition or so. Lordship, kindly record that since I no affidavit has been called for, all allegations I am denying.
Naturally.
All allegations I am denying, and I am also raising the point about maintainability of this appeal.
If we say that they want to withdraw the appeal,
everything.
So then everything.
Lordship. And since I didn't file any objection, so all allegations.
That is not. He is withdrawing the appeal.
Lordship.
My lord, my humble submission is this, my lord. My lord, it is evident from the order of the contempt court, my lord, that contempt court passed the order on 14th August 2023.
Yes.
My lord, on that day, my lord,
you were not aware.
It was not within my knowledge, my lord. So, my lord, I am asking myself, how can I?
What was not within your knowledge?
That, my lord, that's his sister has died, my lord. It was not within my knowledge. At the time of hearing, my lord.
There, Mr. Chaudhary.
Yes.
14th August.
My lord, after completion is submission, I will, my lord.
Mr.
In this fashion, my lord.
14th. Let us cut short the matter. You have heard everything.
My lord.
So do we record that you are withdrawing the appeal?
My lord, that I have to take instruction because we are the advocate, my lord, of the state, my lord. We cannot take decision, my lord, subject to kind correction of your lordship. Because, my lord,
before the contempt in the month of May.
You want instruction regarding what, Mr.
My lord, withdrawal appeal. Because of this, my lord, my lord, first, it is evident from the first line of the order. First line of the order, my lord, that, my lord, learned counsel appearing on behalf of the applicant, that is, my lord, Mr. Pratik Bhattacharya, submits that applicant number 2 expired on 11th September 2020. So, my lord, it was not within our knowledge, my lord. We came to know, my lord, after filing the appeal, because we have filed the appeal, my lord, on 26 June 2023. Thereafter, my lord, on the date of hearing on 14th August 2023, we came to know, my lord, that his sister has died. So, my lord, for this reason we filed the appeal. Now I will, my lord, I will try to impress my officer of your lordship's view, my lord, that what has fallen from your lordship's, my lord, that my lords are wanting that we
We
may
do not
contest.
want. We are not wanting.
I will tell out of my own that we may contest before the honorable single judge in recalling application. So appeal may be withdrawn. If, my lord, they say yes, then I can withdraw, my lord. Otherwise, how can I, my lord? I'm asking myself, my lord. Because
very good. You
as an officer of this court, my lord, I must be fair before your lordship. So, my lord, what is playing in my mind, I have submitted before your lordship.
tomorrow to be mentioned.
My lord, kindly state's appeal, my lord, it is not university's appeal. Then, my lord, I say, my lord, tomorrow. It is state's appeal, my lord. LR has engaged us, my lord. So, my lord, I will take 1 week time, my lord.
When is the recalling application fixed for hearing? Mr.
Friday.
This Friday.
This Friday.
My lord,
Last Friday,
my
they
lord,
took adjournment.
kindly do not record my submission. That will be adjourned, my lord. In any way, matter will not be taken up.
No, you come before that. We will. This is this appeal question of going with this appeal does not occur.
Because, my lord, I have, my lord, 2 ways are there on my behalf. One thing is our withdrawal of appeal and we may contest. But if, my lord, authority say no, it is not within our
Then
knowledge.
you argue on merits. We will decide. We are wanting to know. We are condoning the delay and everything.
Yes,
You argue
then
on
may I
merits?
argue, my lord?
Yes, argue.
My lord, I am grateful, my lord.
Before that, only one thing may I clarify to my learned friend, my lord.
What will you argue? I don't understand. When they themselves say that we are wanting to recall that order, what you will argue?
My lord, for this reason, my lord, I may come back, my lord. May I come back on Monday, my lord?
Not Monday. Come on Thursday to be mentioned. First matter.
My lord, kindly pass an order, my lord. Small order.
In course of hearing,
Last occasion, my lord.
One thing, my lord, may I clarify to my learned friend, my lord, what he is submitting is not correct.
We are not on that, Mr. Bhattacharya.
No. He is saying that he has no idea about the demise of the daughter. On 12th May 2023 order, just now I have shown to your lordship. He is moving on a wrong notion.
Mr. Bhattacharya, if he says that we are withdrawing the appeal, what is your problem, sir?
That is correct. But lordship.
In course of hearing, Mr. Chaudhary, learned advocate,
Grateful one.
Grateful.
But I am for the appeal.
Regarding this matter, Mr. I am applying for state, my lord, led by Mr. Sopal Kumar Datta. I am applying led by Mr. Sopal Kumar. For state, my lord.
In 2022, my lord, the order under appeal.
Higher scale of pay refused.
Yes, my lord.
Refused and my lord, the on the ground of the non-relevant subject.
On the ground of?
Non-relevant subject. He has passed in MA in English, but he was appointed in the, my lord,
Was it hard on affidavits?
no affidavit has been filed by the.
No affidavit.
No affidavit.
My lord, kindly see the trial court's order. Decision was taken by the DI, District Inspector of School, page 56, my lord.
File your opposition. We will decide the matter finally.
My lord, kindly see the entire trial court's order. On decision was taken by the DI, page 56, my lord.
Yes.
My lord, in terms of the order of the Honorable High Court, my lord, kindly see by the under the above circumstances, middle portion, the prayer of the petitioner for sanctioning the postgraduate scale of pay could not be considered for the reason as stated below.
Where are you reading?
My lord, middle portion of the page 56 of the stay petition.
56.
Page 56.
DI's order.
Yes. My lord, the petitioner has obtained master degree in English, which is not relevant subject as he was approved to the post earmarked for physical education teacher. My lord, then, my lord, at present, no vacant post in normal section can be filled up by way of placement of some memo number such and such. 3, my lord. As per GO number 548 secondary education dated 24th June 1997, the petitioner is required to obtain prior permission for appearing at MA examination through the managing committee administrator of ad hoc committee of the school, as the case may be from the concerned district inspector of school, secondary education. As per ROPA rules 98, only those teachers who has improved will improve their qualification relevant to their teaching subject to entitled to postgraduate scale of pay. My lord, he obtained a master degree MA in English, but not required the master degree in English. My lord, he has obtained the physical education teacher, my lord.
Why? There is a division bench judgment on
My lord.
this.
But
Mr. Ali,
Then, my lord,
my lord.
Justice
where have you got?
Page 68, my lord. 60.
On the issue of taking prior permission, there is
Yes.
an order of the division bench.
But kindly pay the 66. Honorable Justice
And my lord-
Chokuto please pass the order.
Memo 57 memo, my lord,
My lord.
which is lying, my lord, 27
Page 66.
January 1995, my
Then
lord, he is
decision was
entitled to
taken
get
by
the
DI and it
higher
was
scale of
challenged
pay.
by the
Since, my
Honorable
lord,
Justice
he was
Chokuto
taking the more than 6 classes.
That will not help you, Mr. Ali.
My lord, decision was taken by the DI. Then it was challenged by the Honorable Justice Oguto Bhattacharya. Then
No,
again.
that order was challenged.
Yes, my lord.
That was decided by
Yes,
Justice
yes, my lord.
Bhattacharya.
Page 61.
Decided and dismissed the writ petition.
10 February 2022. In question of merits, the matter was dismissed.
Then what happened?
My lord, can you see the page 66? For an in portion?
Yes, we have seen that. What happened thereafter?
My lord, Honorable Justice Sugoto Bhattacharya was conclusion of the judgment relevant. He is obtained the degree, master degree.
That is, you are arguing on merit. What
My
you
lord.
are saying? What are you saying? Sogato
saying
Bhattacharya has rejected.
without-
That is why he is here.
My lord, without permission, prior permission by the
That we will hear you.
My lord.
What we have asked him to bring.
My lord. My lord. My lord.
Talk to Mr. Badi. He has those judgments. Take the
He has
give the
already
judgment.
discussed.
Otherwise, we will dismiss your appeal.
My
কিছু নেই মামলায়
division আছে judgment আছে দিও
You have to engage Mr. Badi. Now, why he will?
No, from the beginning, I consulted with the Bari. Bari
Oh,
don't
you
say,
already
yeah, my
consulted.
lord, we never say.
Full consultation will not be there. Two things will be there in the end.
Without material. My lord,
This
I'll
is a bad case. If you can show us any judgment on that, then we will consider.
adjourn for fortnight, my lord.
আবার fortnight কেন? Next week we will hear, next Monday. If Mr. Badi fails to give, you should withdraw the appeal.
কি judgment আছে একটু দিও দেখ
কি আবার judgment থাকে? Any section 5 is there?
No. Within time I have.
লিখে দাও, the present appeal has been preferred challenge.
কত বছর after some difficulties there can be taken up 1920 and 1920 25
Who are your other sides?
one Mr. Sannal was there তোমার 25টা হ্যাঁ দুটোর পরে পারবো না আর করতে পরশু থাকুক পরে হবে না পরশু বলছি
Mr. Sannal, you are there?
বুধবার অসুবিধা আছে
একটা স্লিপ দিন না
other than tomorrow Wednesday Thursday Friday whatever suits your lords
Next Tuesday?
no problem
Next Tuesday?
very well
Next Tuesday is 26th. In
1920 25 get from her
any
No, appellate side টা ডাক। Mr. Sengupta, where is Mr. Shishanno Bhattacharya?
Mr.
Because Mr. Sardai has completed arguments.
I will
No,
take,
I have
that's
not-
why I have come. I will take only
I have
5
not
minutes.
yet concluded, my lord. Last occasion, your lord.
Want to show us anything else? You want to show us anything else?
Yes, because on last occasion, your lordship may remember they were not present, so your lordship adjourned the date of hearing.
All right, point out.
All right,
But
lordship.
you please inform Mr. Shisha, because why we say he is arguing a point before us that on the basis of the written argument which was deposited on behalf of the state, a decision was taken.
Yes.
That is paragraph 70.
Yes. They are
So-
happening on the basis. Yes.
So what he was arguing is that this is an admitted position on the part of the state. But so far as we remember, Mr. Bandyopadhyay has not addressed us on that issue, that whether any such written argument was filed. We do not find. Achha, why we are not finding it in the records, Mr. Shah?
Notice of argument has been filed before the learned single judge.
Then we should be getting, na? In our records, it is
Unless read file is called for, that
read file.
because my lord, they have filed the notice of argument before the learned single judge, and the learned single judge, relying on the same, delivered the judgment so far that particular point is concerned.
But was it not placed in front of you? No copy was given to you.
No, till admittedly, I have also filed notice of argument, but I have also not handed over the copy.
So where is your note of argument? Because what we understood from your submissions is that in view of the proviso, whether the act has been fully implemented or not implemented, the learned judge decided to issue number 2 in your favor, banking on the statement on behalf of the state, and no other reason was given in the order. So unless you satisfy us that no such declaration was there, whatever answer
No,
he will give
subject to
you.
your lordship consideration. If your lordship just give me half an hour to 30,
Yes, tell
that
us.
would be better. I shall clear every required.
আচ্ছা আসুন ফাইলটা দাও তো।
Before my landed significance starts, I filed an application for intervening, not addition of party, because due to the interim order passed by your lordship's court, my selection has been lordship frustrated. I could not be given an appointment since pursuant to the interim order passed by this honorable court. Kindly allow me
like Sutapa.
Yes. Kindly allow me to intervene and make my submission. I don't want to be part of these proceedings, don't want to be added as a party.
At this stage, Mr.
But
Ghosh,
after completion of all the bodies, I'll make certain submission. Around 5 minutes submission, will you please allow me? Just only that.
Has your application
Yes,
come?
can 3, yes, it is on the list.
Yes, Mr. What you want?
Just half an hour according to my way. I shall conclude. But already I have submitted, my lord, challenging some vacancies of fair price shop and some vacancies of MR distributors. Numbers of petitions have been filed. On the ground,
Achha, Mr. Shah, what is the fair price shop and
MR distributor.
marginal? What is that? MR stands for?
Modified ration dealer. Previously, now it is fair price shop. Initially, it was MR dealer, modified ration.
You were an MR dealer.
In some cases, there are 2 types of cases. Some files by the MR distributors, challenging the declaration of vacancy.
No,
Some files by the fair price shop owners. This is a 3-tier system, my lord. The goods are being delivered by the government.
Some have been filed by the
MR distributors, modified ration distributors.
Yeah, give us a time.
আমাকে বলে দিতে কোনো পয়েন্ট তারপর বলবো, হ্যাঁ।
And some fair price
shop dealers. This is a 3-tier system, my lord.
Fair price
shop dealers.
Both have challenged the vacancy notification.
Numbers of vacancy notifications have been issued in respect of dealers and in respect of distributors.
But in this case, it is
There are number of appeals before your lordship.
Oh, acha, acha.
Number of appeals before your lordship. A
But,
bunch of appeals.
Like page 136.
Absolutely. Dates are different. Vacancy dates are different in respect of dealers and distributors. But those who are challenged, interim order has been granted altogether. Ultimately, writ petition has been dismissed. That I shall show you. Just
So, this memo at page, this is a
vacancy declaration
vacancy
notice.
distribution
Vacancy declaration notice in respect of a distributor.
in pertaining to the 2013 control order.
All vacancies under 2013 control order.
Acha, please come to page 136.
Page 137.
136 in Shetara.
My lord. But it would be better if you have to kindly turn to page 139. This is the vacancy decline notice. Page 139.
But your challenge was
139.
1st September.
This is indicative, but 139 is the under challenge.
Your prayer is this. No?
139.
Now your prayer was
Vacancy dated
challenging-
1st September 2022.
Huh.
This is page 139.
Then what is 136?
136 is the indicative newspaper publication.
Oh, I
Same. Kindly turn to page 139, it will clear.
139, yes.
Last three lines says, first paragraph, under the West Bengal Public Distribution System Maintenance and Control Act 2013, as amended from time to time at the following location, the details of the location, block Samserganj, subdivision Jigongipur, district Murshidabad. But this vacancy declaration notice is under challenge so far this appeal is concerned on the ground that my distribution area is the same area. So if this vacancy is declared and ultimately a person is appointed, my dealers which have been tagged with my distributorship, that will be detagged, some dealers, and will be tagged with the newly appointed distributor.
Acha, you are an MR dealer.
I'm a,
Under you, what is the system? Under you, the fair price.
may I just clear according to my way? That would be better, my lord. This is a three-tier system. Allotment order are being issued in favor of the distributors to lift their goods from the government godown.
Yes.
After lifting the goods, they will carry it to their respective godowns and store the same.
All right. These
They
are
are
the MR dealers,
distributors. They are the distributors.
the MR distributors.
MR distributors.
Yes.
After that, allotment order will be issued in favor of the distributors. They will distribute the same to the respective dealers tagged with him.
No, allotment is issued in
by the subdivisional controller to
Now, then who allows you to lift?
district controller. This is called delivery order. On receipt of the delivery order, I shall go to the government godown, produce the delivery order, and they will allow me to lift the goods, and I shall store the same in my godown.
Very good.
Then allotment order will be issued to me.
By whom?
By the subdivisional controllers or district controllers to distribute the ration articles to my tagged ration shop dealers, fair price shop dealers, as per their requirement.
No, the distribute it
Now,
to
so
your
first government agency,
no,
then
to tagged to he will distribute allotment.
I shall deliver it to the fair price shop dealers as per allotment orders.
So that allotment is also each fair price shop dealer.
I'm making clear to you, Lord. So kindly just give me 5 minutes. Some distributors have been tagged with 50 dealers. Some distributors have been tagged with 30 dealers.
No, I don't follow. It is It is
So distributor
modified
is,
ration delivery. You are MR distributors.
so far this case is concerned.
Very good. Now this
So my duty is to lift the goods from the government godown, then distribute it to the dealers who have been tagged with me.
Now, what is the difference between these dealers and
These dealer will
fair
directly,
price shop dealers?
they are the fair price shop dealers.
to
I am
say
saying dealers, they are fair price shop dealers.
So the you distribute it to the fair price shop dealers tagged with you.
My lord. Then dealers will distribute the same to their tagged ration card holders. In some cases, 30, 45, 50 dealers have been tagged with the distributors. And so far the dealers are concerned, 5,000, 6,000, 7,000 consumers have been tagged with the respective dealers. According to their
That is fair price shop dealer.
they will distribute it, they are tagged ration card holders.
So this was this three-tier system. First delivery order.
Government go down to distributor, distributor to dealer, dealer to consumers. Now, if you kindly give me half an hour, entire thing I shall clear.
Please tell us.
So, my lord, we have challenged, dealers and distributors have challenged the numbers of vacancy decline notice on the ground that 2013 control order has become redundant, non-existence after coming into force National Food Security Act and 2015 control order.
Was there any representation to that effect where from we will get what you are arguing?
Everything I shall clear, madam. Everything I shall clear. Just give me to facts, give facts. 2013 National Food Security Act is a new concept. It says targeted public distribution system. For monitoring and controlling targeted public distribution system, central government framed targeted public distribution system control order 2015.
Very good.
I have shown to your lordship, section 3 empowers the central government to frame rule for monitoring, controlling essential commodities. Section 5 of the Essential Commodities Act says that power can be delegated to the different states. Section 5 to frame rule.
Yes.
But Section 5 also directly does not give power to the state governments to frame rule. Section 5 says that the central government shall issue a notified order fixing the terms and conditions in which manner state government shall frame the rule for monitoring and controlling rationing system.
And their argument was that it is not a delegated power, it is an independent power.
They are saying this is a delegated power, but they are saying that,
independent.
To follow the central control order is not required. Section 3 itself gives the power. That is their case. Their case is that it is delegated. But the moment it is delegated, only Section 3 is enough to frame the rule without taking any help of the central control order to be issued by the central government in exercise of the power under Section 5 and Section 3 of the Essential Commodities Act. This is their case. But Section 5 with no uncertain terms says that the central government shall issue a notified order fixing the terms and conditions in which manner state government shall frame rule under Section 3.
Yes.
And following the same, previously there was Central Control Order 2001. Central state government framed 2003 control order in exercise of the power.
2013.
First 2003. Initially 2001 Central Control Order was there. Need not go through the big slider. Initially there was 2001 control order by the central government. Following the same section.
Where is that memo?
Just give me one, it will be clear, better for your lordship. 2001 control order framed by the central government in exercise of the power under Section 5, read with Section 3 of the Essential Commodities Act. Delegating the power to the state. Delegating the power. In which manner you will frame the rule. From the bar, it is being submitted before your lordship that Central Control Order has no manner of application. Section 3 is enough. But when they framed 2003 control order, they exercise power under section 3, read with that central control order 2001.
Where do we find that?
I shall
That is
show
your
just
argument. Huh.
Then National Food Security Act came into force after 2013 control order, saying that the state government shall frame the rule in accordance with the rule to be issued by the central government. Exercising power under section 3 and 5 of the central control order, central government framed 2015 targeted public distribution system control order, superseding 2001 central control order. Superseding 2001 central control order. The moment it is superseded, our case is that 2000 control order became redundant because 2013 control order has been framed in exercise of the power under section 3, read with central control order 2001. The moment 2001 central control order redundant, the 2013 control order also became redundant, and all vacancies issued under 2013 control order automatically goes. I shall show all documents, just I am briefing your lordship. Our case is that you may issue vacancy notice, but following the present law. Ultimately, state government framed a new rule, targeted public distribution system controller 2024.
Then what happened to the 15?
15 is a central control order. Again, I am submitting before your lordship. Section 5 provides central government to
Yes.
delegate the power by
that was a central government.
My lord.
Under the 2013 Act. The 2015 Central Government Control
Control order
is under the 2013 NFSA Act.
I'm getting.
But 2013, the two control orders of 8th of August and 12th of August were under the 2001 Control Order, Clause 7. Correct?
The moment 2015 control order came into force.
2015 comes, the parent control order of one goes. Therefore, nothing under that can remain.
This is my case. This is my case. Absolutely.
Then what you are saying about the subsequent targeted distribution system?
Just 2 minutes. While 2001 central control order has been framed by the central government, the state government rightly issued 2013 control order in exercise of the power under section 3, read with central control order 2001. Right? Then subsequently another control order framed 2013. First 2003, 2013. 2013 also in terms of section 3, read with 2001. Now National Food Security Act came into force, and following National Food Security Act, Central Control Order 2015 has been framed by the central government by saying 2001 control order superseded.
15 control order says in supersession of 2001 control order.
If 2001 goes, 2013 automatically goes.
Has to go. Except for that proviso.
Absolutely.
Then what about
This is my case.
Then what about the 20 subsequent control?
Subsequently, 1st August 2024, they also framed 2024 targeted public distribution system control order, relying on section 3, read with 2015. So it does not, they cannot say that we can frame the rule only invoking section 3 of the Essential Commodities Act. 2003 control order, state control order, 2013 state control order, 2024 state control order, all have been framed relying on section 3, read with the central control order. So they cannot say there is no need to quote either 2001 control order or 2015 control order in the state control order. I am filing the case against the state, not the advocates. State has admitted that position. No opposition in the writ petition. No cross appeal by the state. How can they say 2013 control order we should have framed without relying on 2001 control order? Is it their case? They have followed. Even in 2024, they have followed it. Because section 5, if you just once again taken up the book. Section 3 is the main power. Page 14 of the
Two 2013 control orders are under the 2001 control. Are we correct in that
absolutely,
understanding?
absolutely.
Then what
I'm
happened?
just giving reference, because state is following. What I am saying, state is following all together.
Now, what has happened to that 2003 control order then?
Repealed. They framed 2013 control order following the same procedure. Section 3, I read with section 2001 central control order.
Then 2003 control order has been superseded.
By 2013, state has framed the new rule. State has framed the new rule, 2013.
The 2003 control order was by the central government.
No, 2001. 2001 was the same.
2003 was a state one.
State control order.
2001.
First.
So 2013 control orders were in supersession of 2003.
State control order.
State
Yes.
control. So till 2013, the 2001 control order remained.
Even 2013 was right. But the moment
that proviso came in, that's your
2015 control order came, according to us, you cannot. Because 2015 says 2001 central control order superseded unless fully implemented. From their document I have shown to your lordship, it has been fully implemented in 2016. Only reform, except reforms, but reforms is continuous process I have shown to your lordship. They affirmed an affidavit.
That proviso is of which control order?
2015. I shall show to your lordship.
Yes.
Now, your lordship, kindly take up section 3 and section 5 of the Essential Commodities Act. It will be clear. May I read section 3? Power to control production, supply, distribution, etc. of essential commodities. 1. The central government is of opinion that it is necessary or expedient so to do for maintaining or increasing supplies of any essential commodity or for securing their equitable distribution and availability at fair price shops, or for securing any essential commodity for the defense of India or the efficient conduct of military operations. It may by order provide for regulating or prohibiting the production, supply and distribution thereof and trade and commerce thereon. Then, my lord, 1A, B, C, D are there. So, my lord, it is power only to the central government. So far the essential commodities is concerned, that control can only be done by the central government invoking section 3. Now, your lordship, kindly come to A, 2A. May I read, my lord?
Yes.
For regulating by license, permits or otherwise the production and manufacture. D, for regulating or license, permits or otherwise the storage, transport, distribution, disposal, acquisition, use of consumption of any essential commodity. For prohibiting the E, for prohibiting the withholding, requiring any person to sell the whole, so on so. So this entire power has been vested to the central government under section 3. State has no power under section 3. Now, your lordship, kindly come to section 5. Delegation of power. Have you lordship got one? Section 5. The central government may, by notified order, well, this is my case, by notified order, direct that the power to make order or issue notification under section 3 shall in relation to such matters and subject to such condition in the notified order. In the notified order. If any, as may be specified in the direction, be exercised will also by such officer or authority subordinate to the central government. Next, such state government or such officer or authority subordinate to the state government. So this is delegation to the state. Not section 3, not section 5 alone. By issuing a notified order, fixing the terms and condition in which manner state shall frame the rule. This is Central Controller 2001. This is Central Controller 2015. Unless there is a Central Controller, state cannot enjoy the delegating authority as delegating. That has been done by the central government by issuing first 2001 Central Control Order for public distribution system and 2015 targeted public distribution system. It with no uncertain terms says by issuing a notifying order, fixing the terms and condition. In which manner state shall frame the rule. That will be done by the central government issuing a notified order. Following the same.
But the central government may by notified order direct that power to make orders or issue notifications under section 3 shall in relation to such matters will also be exercisable by the specially be exercised by such officer of the state government.
Can you read the last two lines of the in relation to such matters and subject to such conditions, if any, as may be specified in the direction be exercised. Well, this is the notified order.
This direction is the notified order which central government is issuing.
Empowering the state to frame rule in this manner. How license will be issued? In this manner. How distribution will be given effect to? In this manner.
Now, what is their contention? Their contention
is different to the state stand. State all together have framed the rule 2003, 2013.
Whose contention is against the state stand?
Their statement is that there is no need to take help of notified order. Section 3 itself gives the power.
Section 5.
Section 3, according to them, because Section 5 says state shall frame the rule under Section 3. The central government may, by notified order, direct that the power to make order or issue notification under Section 3.
So it is the state's contention that there is no need to take help of a.
I'm not saying so. State contention is very clear by their conduct. They have all together take help of the central control order. It is from the board.
You are asking. So your contention is that the state has argued that there is no need to take the help of Section 3 in terms of Section 5 itself. I can issue.
No.
Your contention is no. Section
State
5.
contention is that the moment power has been delegated to the state by Section 5, they can frame rule in.
By Section.
Section 5 empowers the state governments as delegated to frame rule. According to them, only using Section 3, they can frame the rule without taking help of central control order. Without taking help of the central control order. That is 2001 and at present 2015. But their conduct says they have all together took help of these central control orders. The moment they frame rule 2000.
Slow, sir. We are. So it is the state stand that there is no need to take help of any central control order. I can do it. I can do it on the basis of Section 3 delegation itself.
Absolutely.
Now, where does Section 3 delegates the power?
Section 3 never delegates. Section 3 is the power to frame rule for controlling essential commodities. Section 5 gives the power to the states to frame rule under Section 3, read with central control order. Because Section 3 only empowers central government, but that power has been delegated by Section 5. That for controlling, monitoring essential commodities, state can also frame rule, but that rule should be consonance with the central control orders.
Very good, very good.
Am I clear to your lordship? So central control order is actually
without central control order, you cannot proceed.
That's Section 5. That's section 5. And they have done so altogether, even in 2024. 2024 control order says, in exercise of the power conferred under section 3 of the Essential Commodities Act, read with 2015 Central Control Order. 2013 same, 2003 even was same.
Is it the contention that section 3 does not give any power to the state?
Absolutely. Absolutely no power.
Section 3
He only to the central government. So for the controlling monitoring of Essential Commodities Act is concerned, that can only be done by the central government. It is the contents of the section 3. Now section 5 gives the power to the central government to delegate the power to the states by issuing a notified order, fixing the terms and condition in which manner they will frame the rule.
No, then section 3, if your argument is accepted, then section 3, then where this suppose in a case section 3 exists, but there is no central control order. If central control order is not issued, then state becomes powerless.
Absolutely.
So we are wanting to know from you, is there any element in section 3 which gives power to the state independent?
No. For monitoring, controlling power, section 3 only central government.
Very good. Then what is their contention?
Their contention is that immaterial to the fact whether there is a central control order or not.
I can frame under section 3.
Since section 5 delegated the power, but they are not saying section 5 ipso facto does not give the power to the state government. It says by issuing a notified order.
They are saying that there is no section that central control order is not required. I can frame it on the basis of section 3 itself.
Since section 5 delegates the power by the central government. Because
since I didn't understand why you are making this. Since section
again I am repeating, just 2 minutes. Section 3 is a power vested to the central government to monitor, control essential commodities.
Very good. Yes.
Stop. Only state central government. But exercising power for essential commodities has been vested section 3. Now section 5 says central government may by notified order empowering the state governments to frame rule in accordance with the central control order, not section 5, in exercise of the power under section 3.
Right, yes.
Because unless section 3
there's a notified order, even under section 5, the state government can't issue a control order.
Absolutely. This is my case. Unless central, because why I'm saying so, National Food Security Act came into force 2013 July.
I didn't, your explanation as regards state contention is not being clear. What is their stand? That no central control order is required.
Yes, that is the from bar. Again, I'm repeating from bar.
Right, right.
Why I am saying so? Kindly take note of 2001 central control order. According to them, no need. But when they framed 2003 control order, they
mentioned that.
2013
also
same,
they mentioned.
2024 same, no affidavit, no cross appeal. Where from they are saying so? It is not the state stance, it is the stance from the bar. No affidavit has been used in the writ petition, despite giving numbers of opportunity. Not a single line affidavit, not even in the report. 2 reports have been filed. There is no whisper that there is no need.
No, very good. On the bar, what is being said?
They are saying Section 5 is there, Section 3 is there. Section 5, the moment delegates the power to the states.
By central control order.
They are saying not need. They are saying Section 5 itself has gives the power. So they can frame rule in exercise of the power under Section 3.
They can, so their stand is they can frame control orders on the basis of Section 5 itself.
Section 3 itself. Section 3 itself. You can,
this is where we are.
because Section 3 controlling monitoring power only has been given Section 3.
Very good. Now Section 3 is the power given to central government.
Yes.
That cannot, court cannot exercise Section 3 power unless it is delegated by a central control order. Central control
Absolutely.
order. Now we are wanting to know that then
Their case is that they are on.
State has
Yes.
not controverted such procedure.
But the bar, they says the moment Section 5 empowers the state governments to frame rule.
Yeah,
they can frame rule in exercise of the power under Section 3. That is their case.
Moment
no notification is required.
No, what is this? And the moment
the moment Section 5 empowers the states to frame rule by the central government, immaterial to the fact whether there is a central controller or not, they can frame rule under Section 3.
Very good.
Now, Your Lordship, kindly 2-3 provisions. Kindly come to my page 146. 2001 control order. I have annexed in my stay application.
From the bar, it is arguing the moment Section 5 empowers to frame rule.
Delegation.
When the power is given under Section 5, then automatically I can issue the control orders. As I have done in respect of the new act also under the National Food Security Act.
No. Their conduct is something entirely different. All state control orders has been framed in exercise of the power Section 3. Read with central control order. I am repeatedly saying this is the bar. This is from the bar. Even 2024 control order has been framed by the central government, state government in exercise of the power under Section 3. Read with central control order. 2015.
So, can you take us to that Section 2024 control?
I shall, because before that, Your Lordship, kindly just see 2001 control order, page 146. It will be clear. Page 146 of my stay application. But this is dated, date is not that, 31st August 2001. Why I am saying
this is the central control order.
2001 central control order.
Framed under Section 3.
Section 3. Kindly read second paragraph. Now, therefore, in exercise of the power conferred by Section 3 of the Essential Commodities Act, the central government hereby makes the following order, namely, this order may be called the Public Distribution System Control 2001. But then kindly come to page 150.
150.
But this is the source of power. How and which manner they will frame the rule. State will frame the rule. Kindly see 7. Licensing. The procedure for issue of license or authorization to the fair price shops for the distribution of essential commodities under public distribution system and duties and responsibilities of the fair price shop owner shall be as per paragraph 5 of the annex to this order. So, my lord, section 5 says,
We will listen to you. Yes, yes.
my lord, I have shown to your lordship that section 5 says notified order fixing the terms and condition. 2001, fixing how and which manner license shall be issued. Kindly come to the annex chart, page 160. Licensing.
Fixing the terms and conditions where?
I'm showing to your lordship.
Now,
Prescribed as the fair
what
price shop
is your
shall be
explanation to this?
as per paragraph 5 of the annex C. Kindly come to page 160.
No, Mr. Shardai, you have showed us clause 7 of that central
Last 2
control.
line, kindly see paragraph 5 of the annex C to the order.
This is for the
License of the fair price shops. 2001. Kindly come to page 160. Which manner license shall be issued?
Yes.
5, annex C 5 at page 160. State government shall issue an order under section 3 of the Act for regulating the sale and distribution of the essential commodities. The license to the fair price shops owners shall be issued under the said order by the designated authority appointed by the state government, and the authority shall lay down the duties and responsibilities of the fair price shops owners. The responsibility and duties of fair price shops owners shall include inter alia. So this is the manner you have to frame the rule.
But first line kindly read.
The state government shall issue an order under section 3.
How they can issue? They have no power under section 3.
Section 3 is the only power to monitor, control essential commodities.
That is central government.
That has been delegated section 5. But the rules should be framed under section 3. Section 5 does not give power to frame rule for controlling essential commodities. It gives section 3 power. So section 5 says you shall frame a rule under section 3, read with control order, monitoring, controlling.
Where that read with control order? Section 5, clause 5.
Clause 5, licensing, have you lordship, my lord?
Licensing.
So,
state government shall issue an order under section 3.
Yes.
For regulating sale. Where it is said that state government shall, oh, you are meaning to say that by this control order that power has.
Yes. This is the notified order. This is the notified order. It specifies that you can frame the rule in this manner, in this manner. In this manner. This has been exercised by the central government under section 5. Empowering the state government to frame rule in this manner. License should be issued in this manner. Distribution should be in this manner. According to them, there is no need.
How that power to monitor is what is delegated under section 5, so that the control orders framed are under section 3.
I'm grateful to lordship.
No,
this is one-line argument. This is one-liner. Absolutely. Absolutely.
State government shall issue an order.
Source of power is the central control order.
The central control order is the delegation.
Absolutely. Section 5 says you will notify an order delegating the power. This central control order is the source of all states to frame rule under section 3, monitoring, controlling essential commodities. And this has been framed under section 5, delegation.
Now, on the basis of this.
First 2003 control order, I have handed over to your lordship. 2003 control order.
Where handed over means earlier.
Earlier, 2003 আছে 2003 control order. এগুলোই হবে
No.
Misleading type of correct.
Arises is on interpretation of this first line of clause 5 of the central control order.
I have no confusion.
No confusion. If you read it independently, state government shall issue an order under section 3.
Yes. Yes. Again, I am saying yes.
But that delegation is by the central government order. Central control order says that now you exercise
Under section 3.
Under section 3.
Yes. This notified order actually the source of power of the different states. Because section
What is being delegated is the powers under 3. The way it is delegated is the process under 5.
central government order is a product of section 5, which empowers the states to frame rule under section 3. Am I clear? Now kindly read my section 2003 control order. The Lordship has taken, kindly read. The governor is of the opinion that is necessary and Kindly read, my lord. Second paragraph. It has been notified on 31st December 2003. Now, therefore, in exercise of the power conferred by Section 3 of the Essential Commodities Act, related the Government of India, Ministry of Consumer Affairs, Department of Food and Public Distribution Order, GSR 630 dated 31st August 2001. This is page 146. Because this is the source of power. This is their case. States. Now, your lordship, kindly take up 2013 control order. I'm handing over the book.
2013 we have.
Same. State control order. No, annexed. It is annexed. It is annexed. Page by 165.
Yeah, 165.
Sorry. Kindly read page 165, second paragraph. Now, therefore, in exercise of the power conferred by Section 3 of the Essential Commodities Act, read with the Government of India, Ministry of Consumer Affairs, Food and Public Distribution System, GSR, dated 31st August 2001.
Very good. Now comes the national security.
Yes. Now, national entire scheme has been changed. If you have to kindly turn to page 209. Altogether, there was public distribution system. Now, targeted public distribution system. Entire concept of the rationing system has been changed by virtue of promulgation of National Food Security Act. This is subsequent to 2013 state control orders. Date is September 10, 2013.
This targeted public distribution.
TPDS, Targeted Public Distribution System.
And before it was
Public Distribution System. Kindly see National Food Security Act 2013, notified on 10th September 2013. Previous state control orders were 8th August and 12th August. Now kindly come to my lord. All scheme has been changed. I have submitted before your lordship. BPL, APL, all goes. Now only eligible households, priority households. Entire scheme has changed.
now come to page 227.
227. This is
Central order.
central control. 20th March 2015. Whereas the central government is of the opinion that it is necessary and expedient to so do for maintaining supplies and securing availability and distribution of essential commodity, namely food grains under the targeted public distribution system. One of my point, you cannot issue a license under previous control order, central control order, because there is the provision for target, there is the provision for eligible households, there is the provision for priority households. You are issuing a license under a control order which deals with APL ration cards, BPL ration cards.
So your argument is that after the NFS came, the central order which has been framed, that is pertaining to the targeted public distribution system.
Yes.
From this also it appears that you cannot pursue the 2013 control
After coming into first 2015.
because that is pertaining to public distribution.
Absolutely.
The entire concept
Absolutely. By G-stop case.
very good. Now
May I read my 227?
Eh?
227, second paragraph. Kindly first paragraph, last line. Food grains under the targeted public distribution system. Then, now therefore in exercise of the power conferred by Section 3 of the Essential Commodities Act 1955 and in supersession of the Public Distribution Control 2001. So 2001 goes except except as respect of things done or omitted to be done before such supersession and save as otherwise provided thereunder, the central government hereby makes the following order. My case is that I have been granted license prior to 2015. Things done, my license will continue. Then
No, they just have been given
distributorship or dealership license in all cases prior to 2015. So this saving clause saved my license.
no, these licenses are given to MR distributors as well as to the free
Car price shop dealers who has filed the case challenging the different vacancy notices.
So you have been given the licenses all under the
2013 control order, but prior to coming into force, 2015 central control order. Anything done or omitted to be done before such supersession. At the time of granting license, 2001 central control order was in force.
license was granted. Now you are continuing with that license even after coming into force of the new
Because since it has been granted at the time of 2001 control order was in force, that's the language of the second paragraph. Now, therefore, in exercise of the power conferred by Section 3 of the Essential Countries Act and in supersession of the Public Distribution System Control 2001 Central Control Order, except and respect of things done or omitted to be done before such supersession. So my license has been granted prior to this 20th March 2015. At that material point of time, 2001 control order was in force. Anything done that has been done prior to 2015. License have been granted prior to
that will not be touched by
yes,
this.
yes. Now, next paragraph. Short title and commencement. This order may be called the targeted public distribution system. Entirely changed. Control 2015. This is not public distribution system, targeted public distribution system. Now, next paragraph is very vital. It shall come into force on the date of publication of the official gazette, provided this provided is the case sought to be made out by the state and the private respondents. Provided that provisions of the Public Distribution System Control Order 2001 shall continue to have effect as against the corresponding provisions of this order in any state which has not implemented the Food Security Act or is implementing the said act only in part. According to them, till that date when these petitions were moved, they had not fully implemented National Food Security Act. Since there is a saving clause that if any state did not implement the National Food Security Act, in that case 2001 control order will continue. Am I clear to your lordship? Again, I am reading. Provided that provisions of this public distribution system, meaning thereby 2015 control order, shall continue, 2001 shall continue to have effect as against the corresponding provisions of this order in any state which has not implemented the Food Security Act or is implemented the said act only in part. According to them, partly they have implemented. So, in our state, 2001 will continue. And if 2001 continue, then 2013 stands, and 2013 if stands, they can declare vacancy under 2003 state control order.
That is from the bar.
That is from the bar. Licensing.
So the state says that as it has been partly implemented.
2001 till exits. On one hand, their submission. 2001 has
complete. State says that partly it has been implemented, and as such, what will continue according to them?
2001. On the one hand, their submission is 2001 has no manner of application.
Central control order will continue.
On the one hand, their submission is
all day, all for eternity, because never that
because license is till the death, unless there is a termination or cancellation. It is renewal process is there. But my case is that, so far I am concerned, after coming into force to 2024 control order, a new license has already been granted to me under 24 control order. As a continuation, already granted in all the dealers, all the distributors. Since I accrued the right under 2001 control order, while 2015 was not in force, the moment 2015 control order came into force, ultimately they framed a rule to 2024, and license under 24 control order has already been granted to all my clients.
where is the 24
Before that, Your Lordship, kindly say why I am really relying on 2015. Kindly come to my lord, page 245. Take note of. One hand, their submission 2001 Central Control Order, 2015 Central Control Order has no manner of application. Only Section 3 empowers them to frame rule. Now they are saying, other hand, since we have not fully implemented National Food Security Act, so 2001 is applicable in our state. Am I right? On the one hand, their submission, they can frame rule without taking assistance of Central Control Order 2001 or 2015. In their affidavit, they are saying, report, since State of West Bengal has not fully implemented National Food Security Act, 2001 will continue. This is contradiction.
Now, where is this provision of vacancy declaration under 2000?
Yes, kindly come to page 245. Under 2015 control order, clause 9. Page 245, clause 9. Licensing.
Yes.
Licensing and regulation of fair price shops. The state government shall issue an order under section 3 of the Act, but not inconsistent with this order. This is the notified order. It's very specific. For regulation, the sale and distribution of the essential commodities. Next, 2. The license to the fair price shop owners shall be issued under the said order, and the order issued by the state government shall be notified and displayed in the web portal. So after this, you have to frame a rule, new rule, and then only vacancy.
Why do you say that? Please read again.
Licensing and regulation, clause 9 I am reading. The state government shall issue an order under section 3 of the Act, but not inconsistent with this order, for regulating the sale and distribution of the essential commodities. Section 5, delegation, notified order. This is notified order. In consistency with this order, you have to frame a rule. Next, the license to the fair price shop owner shall be issued under the said order, to be framed by the state, in consistency with this control order. And the order issued by the state government shall be notified and displayed. So state has to frame a rule consistent with this central control order. Section 5, notified order. The designated authority appointed by the state government shall issue the license. Subsection 4, priority would be given to the who? Panchayat, local bodies, corporation, societies. Everything has been clarified. In this manner, you have to frame the rule. The license to the fair price shop owner shall be issued keeping in view the viability of the fair price shop.
They are asking you where is that vacancy? Vacancy will be in terms of the new order.
Vacancy license. License should be given under this control order.
Right.
So license, vacancy is the initiation of these proceedings. You are going to give a license under following 2015. Can you declare a vacancy under previous control order which has already been superseded?
Where is that power of declaration of vacancy in this?
My lord, licensing, power of licensing has been denoted.
Right.
The licensing is the need for declaration of vacancy is the license.
That is your argument. To satisfy us on that, the question which we are asking. Let us come, please come back to the vacancy notification, page
Yes.
180.
2013 control order. Yes.
No, no.
139.
130. What does it say?
Kindly see the date first. 139.
1st September 2020. In
First-
pursuance of the approval of vacancy of distributor, FIDE order number
So and so. The
Third
department, yes.
22. Date be 22nd August when the food
These are the approvals of the Department of Food and Supplies, Government of West Bengal. Applications are invited from individual permanently residing in Murshidabad, registered partnership firm, registered cooperative society, Shangha, Mahasangha of self-help groups, working within the district of Murshidabad for filling up the vacancy of distributor
this vacancy
under 2013 control order.
the 2013
In 2022,
2013 control order shows the declaration of vacancy portion there.
kindly take up the book. No, 2013 is also annexed.
You have annexed.
Yes.
That is page 289.
165.
Files you have annexed. Here,
I'm showing to you. Kindly come to page 171.
page 1.
Now, this is dealer and distributor is also there. If your lordship desire to show, I shall show to your lordship the one. Clause 26 at page 174.
Yes.
Engagement of distributor at page 174.
Yes.
Kindly come to last paragraph, part 1, Roman 5. After obtaining government approval, district controller food and supplies shall issue an order, offer letter informs so and so. Engagement of, that is there. Kindly come to Roman 2, P2, top middle portion. If it appears necessary for the district administration, have you also got?
Page
174.
174.
174. Engagement of distributor 1A, B, C, D, E.
Yes.
Roman 2.
These are the sequences when vacancies will arise.
Yes. Then
if it appears.
yes, Roman 3. Applications for filling up the vacancies as notified. Roman 3. Shall be invited from so and so, so and so, so and so. So following this control order, vacancies have been declared in 2022. Our case is that while 2015 control order came into force and you have fully implemented the same, this automatically goes by virtue of supersession of 2001 main central control order. You cannot touch 2013. You have to frame a rule, then you have to declare the vacancy. As per terms and condition of the central controller 2015.
Yes. Anything else to show? Anything else you want?
Yes. They have argued, they have relied on the judgments also.
Yes.
Well, now, Your Lordship, I have placed before Lordship 2024 control order. Kindly take note of the 2024 control order. But kindly read what they are submitting and what they are doing. This is well, kindly see the date. Page. First page.
This is a fresh control order
Targeted public distribution system.
2024.
After 2-3 pages of the book, after index. Oh, biology kindly take. West Bengal Targeted Public Distribution System Maintenance and Control Order. Kindly take note of. Whereas the Governor of India, Minister of Consumer Affairs, so and so, Public Distribution System exercise the power conferred by Section 3 of the Essential Commodities Act. Read with control order. Kindly read, my lord. 2015. In exercise of the power under Section 3(5), read with 2015 Central Control Order. They are admitting without taking assistance of the Central Control Order, no rule can be framed by the state government because this is the source of power. 2003, 2013, 2024 even.
Yes.
Now, this order may be called the West Bengal Targeted Public Distribution System. Licensing, everything has been disclosed following the 2015 control order. Which manner license shall be issued, who will be entitled to get it, who are the preference class, following 2015.
Yes. Now, where is that you have been given under the continuance of license? License you have been given under the new control order?
But these all matters have been filed prior to coming into force this 2024 control order. But if your lordship asks, I shall hand over all those. There is no dispute. State also not disputed because these matters have been filed coming prior to 1st August 2024. Almost more matters. So at that material point of time, I was running my business under 2013 control order. Subsequent to filing these writ petitions, 2024 control order came into force, and I have been granted new license under 2022. I shall show to your lordship. In all cases. Now, resolution or termination, it will continue. Now, your lordship, kindly take up. One fact has been happening in the meantime. What happened? State has framed a new scheme of dual-ration. I have submitted before your lordship. Dual-ration scheme was under challenge. Numbers of points has been taken. One of the point was 2013 controller became redundant. Matter went up to the division bench. Before the division bench, it was the submission of the then Advocate General that since we have not implemented National Food Security Act in its full terms, we are able to declare the vacancy or something else under 2013 state control order. Our case was that not you have fully implemented. The Honorable Division Bench quashed and declared ultra-virus dual-ration scheme, but observing that since the Learned Advocate General submitted before the Division Bench that it is state has not fully implemented, we are not considering these aspects of the matter.
Dual-ration scheme is
State scheme
that is a
under 2013 control order.
Dual-ration was under
Separate scheme. Ration has to be delivered to the doorstep of the consumers. This is a state scheme, not the central scheme. Dual-ration scheme means the dealers are liable to deliver ration articles to the doorstep of the consumers. The state scheme. Dealers Association have challenged the same. That since central control order did not say that it is the duty of the ration shop owners to deliver the goods to the doorstep of the consumers, we cannot force us. The division bench declared ultra-virus dual-ration scheme, contrary to central control order. But it was observed. So for the point we have taken that 2013 control order redundant after coming into force 2015 control order, division bench held since the Learned Advocate General, the then Learned Advocate General submitted before the court that state has not fully implemented National Food Security Act, so 2001 control order will continue. After declaration of ultra-virus, state preferred an SLP,
which was declared ultra
dual-ration scheme.
Because
But that point has not been considered. Other points. Now state prefer an SLP. In page 54, grounds number R, before the Supreme Court, Joint Secretary affirmed affidavit saying the submission which has been recorded by the Honorable Division Bench on behalf of this is not correct. Now, subsequent to that too, another writ petition was moved before this court. Both of my learned friends was Mr. Sushoman Sengupta and Mr. Dhara. Mr. Dhara moved the writ petition. Mr. Sengupta says it has not been fully implemented. The writ court dismissed the writ petition. Matter went to the division bench. This SLP was placed before the same division bench, Justice Das. Criticized the state, saying it is not correct to say that it has not been fully implemented. I have handed over the judgment copy of that. Deepta Kumar China. Deepta Kumar China. The division is Deepta Kumar China, division bench order. And passed an order, stay.
That has not been disposed of. This is pending.
Ultimately, that has been dismissed for default or withdrawn. But kindly see the observation for. And interim order has also been passed. Same division bench. If 50 feet আছে is 50 করে জেরক্স করে নিয়েছেন একটা পৃষ্ঠা কপি আছে আগের দিন দিয়েছি তো এটা দেখুন একটা করে পৃষ্ঠা আছে একটা করে পৃষ্ঠা আছে পৃষ্ঠা মাঝখানে আইলে নেই তো
Yes, which portion here?
তাহলে বের করুন kindly come to page 4, inner page 4, second paragraph. Taking into consideration. Have you also got?
Second.
Page 4, inner page 4 of the judgment order. Second paragraph. Taking into consideration the submissions advanced by the learned counsel for the parties, we are of the view that there is clamor for legality of the impugned action in view of coming into force the Central Control Order 2015, proceed by National Food Security Act so and so. The appellant being stated to be supplied with PTS items so and so. So there is a clamor after coming into force, whether 2013 Control Order is in force or not. Clamor after coming into force.
No, that issue has not been decided.
No, not decided, but division bench passed interim order holding that there is a clamor. So for the submission made previously, before the duration scheme, that it was not fully implemented, that stance has been, and the learned single judge recorded everything, division bench, this judgment. What? Only one paragraph. Since in the notes of submission, learned state advocate submitted, it is not. I shall show to your lordship.
Yes.
Now, your lordship, I have already submitted 3 points have been, 3 issues have been framed by the learned single judge. First issue,
That we have seen.
no. Only first and third issue in my favor, second issue, holding so and so.
So you now deal with the judgment.
Yes.
That should Mr. Bandyopadhyay, that paragraph 17, that reference to the written argument.
Yes, Malad, that is,
Where is that?
no, Malad, that is something, Malad, Mr. Shahara has been pressing on that point. But if your lordship sees the order, where the,
No, we want. We
I'll
want
tell
to
you,
see.
when
No, where is it?
written notes, Malad, I'm, in fact,
We have not yet got it.
I'll
What you submitted to the court.
that it is not fully implemented, but it is immaterial. He's harping on that point.
That we will listen to.
I'll tell you Rajiv, why. Because in that order, the other order of a coordinate bench, division bench of Abdul Majid is referred to. In Abdul Majid, the submission of the learned advocate general is recorded that NFSA is not implemented fully. I have only reiterated that point, nothing more. My written notes cannot have a greater value than an order of a division bench. The recording is there in the division bench order, where Mr. Shah himself appeared.
That is the court's record.
Right.
Court's record.
The same thing has been stated in the written notes.
No, not reiterated. Then you have to take responsibility of that. So appeal court referred to that. I have repeated the same statement. That does
and
not.
Subsequently, before your lordships, we have filed affidavit suggesting so.
That is separate. That the affidavit not fully implemented, you try to substantiate. But if there is an admission on your part, it has been implemented.
Not fully implemented.
Not fully implemented.
Not fully implemented.
But yours kindly come to paragraph 17 of the judgment given. Read that paragraph. Why should we allow you to go to any other point after this? Please show.
May I just come back? Has not fully been implemented.
Yes.
That certain provisions of NFSA has not fully been implemented in the state of West Bengal.
His contention is right.
But his contention is nowhere in view of the fact that it is the consistent stand of the state.
Please don't go to that. Call a spade a spade. What is being written here, you tell us.
It has not been fully implemented.
Yes. However, it is pertinent to note that Mr. Sajjan sir, in his detailed note of arguments, as categorically stated, has not been fully
Implemented, yes.
has not been fully implemented. Then the 2013 control order continues.
Continues.
Yeah. That is your contention.
Yes. Yes.
Please show us that where is your written undertaking.
But our case is that it has not been fully implemented. In fact, I intending to show it, Malad. Yes, Malad, kindly Malad takes internal page 4 bottom. In the stay application 332, but kindly internal page 4 bottom kindly takes. Yes, madam.
You have said that it has been fully. Please remove our confusion.
It is not fully.
You put it as a
Not fully. এই স্টেটমেন্টটা বাই দ্য অ্যাডভোকেট জেনারেলটাকে চ্যালেঞ্জ করেছে। অ্যাডভোকেট জেনারেল বলেছিল ফুলি ইমপ্লিমেন্ট।
Yes, that statement that it has been fully implemented by the Advocate General, that before the Supreme Court, according to you, was a misrecording of the state. So if it's a misrecording, did you file any application to the review?
No, it is not. It is not. Well, that is why I was intending. Well, can I take internal page 4 bottom?
Remove the confusion at this stage. Let us
But
understand.
kindly start from internal page 4 bottom.
পেজ 5 তে এসো। Internal page 4.
Last 6 lines. Or may I read it?
দুয়ারের অ্যাকশনটা নিয়ে চ্যালেঞ্জ করছে ওই জায়গাটা একবার দেখো তারপরে পরের পাতায়
No, it has nothing to do with the Supreme Court, my lord. Kindly, this, my lord, what is there in the order of the division bench? The factual position is that?
The Advocate General said not in.
Yes, that is the stance of the state.
No, what is kindly come to internal page 333.
333, yes, my lord. I was pointing out to that only.
Yes.
Internal page 5. Starts from page 4, submission of the Advocate General, and thereafter a ground has been taken in the SLP. That is the crux of the situation. But the state is affirming an affidavit saying that it has not been fully implemented.
No, but your ground before the Supreme Court was wrong in recording that it's not been fully.
That is the only thing.
Then
It is
what
the
will
ground does not
state
say,
claim?
the ground has never said, nowhere it has been said that NFSA has been fully implemented in the state.
Your contention. Has Supreme Court said anything on this?
My lord,
That it is a wrong record?
no, but no clarification is required from the Supreme Court because it has no clarification has.
That is your argument that in the context of the matter, it is immaterial whether we have said so or we have not.
We have not said so.
So we being a division bench, we are asking you, then we will record your statement to the
That NFSA is not fully implemented.
No, the learned single judge has proceeded. What is the reasoning for why this appeal is filed? Appeal has been filed by them only due to non-answering that issue 2, which is an offshoot of the third.
Fine.
So even if this is on record, you still, if you want to argue that it is not, it was a wrong recording or right recording, you need not apply your mind. You listen to us. We are saying this, you can deliver judgment on.
Yes, my lord, our stance, factual stance with regard to this question.
So then you are admitting that there was a wrong recording on behalf of the state.
No. What?
It's 333.
Kindly see the SLP ground. SLP ground.
SLP ground is
Just one thing. It is already mentioned there. My lord, our stance, as has been submitted by the Learned Advocate General in that matter of Abdul Majid, that NFSA has not been fully implemented. which is reflected in my submission in paragraph 17 and reflected in the affidavit which has been filed before your lordships, affirmed on 13th of August 2024, that why it has not been fully implemented.
No, Mr. Bandyopadhyay, I think we are not being able to express ourselves sufficiently. We are not questioning your stand.
State stand.
Correct. You means the state. What we are asking you is, in ground R, you have said that that's a wrong record.
Wrong recording.
So if it's a wrong recording, that it has not been fully implemented, that's a wrong recording, then what's the correct recording?
I'll tell you, Lordship.
That it's been fully
My
implemented.
Lord, the ground R at page 54 of the SLP is in the context of that matter.
Whatever may
My Lord,
be
it has nothing to do with the fact.
answering our query.
With the fact, my Lord, the answer to the query is that factually NFSA has not been fully implemented in this state, and the factual details of this non-implementation.
How can you say so after that recording before the Supreme Court?
Well, it is in the ground. That recording in the ground, well, that is been on affidavit has been said.
It expunged from the Supreme Court.
But that's a different matter. It is not in the finding of the Supreme Court. We need not take a clarification from there.
Staring at our face, then we will pass our order that you get it rectified. Let
You
them
see
continue.
paragraph 17. The
17.
Learned
Yes.
single judge has relied on that submission made by you in your written notes and proceeded to come to his finding.
My Lord, submission, what I am trying to say is that I am not escaping from my submission. I am saying what my submission is the consistent submission of the state in different matters. Also in this matter.
Mr. Bandyopadhyay, ground R has to go.
Ground R, but that at the appropriate stage it will be taken care of, my Lord. Why I say this? Because this is not a finding of the Supreme Court. It is my ground taken in my appeal
Finding when you go and say that this has not been
in
done.
the context of that matter. That it is, the ground is not that NFSA is fully implemented.
You tell us before us that yes, that defect is there, but still I insist that you decide the matter.
Malad will kindly,
Say us that
Malad will kindly take the affidavit affirmed in August 24, Malad.
we will go to every documentation. We are asking you a question, let us not divert from it because we are hearing this.
Malad, answer lies there in the affidavit.
We will go answer what your argument is that that submission was made in the context of that matter.
Malad, that matter has been affirmed by a state officer.
Accepted. Because it is not a question of that officer concern. You are saying that please understand what
Malad,
is your query.
I bow down to the question, Malad.
That Mr. Bandyopadhyay, does that ground exist? Yes or no? It exists.
Malad, the ground is
Wrong statement. No, let us
in that context. In that context, Malad, the context is being taken out of this entire situation. The context is being put in a different picture altogether.
So, without disclosing the proper state of affairs for which the court has not granted to a conclusion, you are saying that accept that as the proper state of affairs.
This 13th August 2024. 13th August 2024, the affidavit which was directed to be filed by the coordinate bench, that paints the right picture. That is the answer.
13th August means
Malad, there is an affidavit affirmed by the principal secretary as directed by this court.
that irrespective of what has been stated by the relying upon the affidavit of the concerned officer, we need not remove that confusion.
But
But still on that.
But Advocate General submission is same as paragraph 17.
Paragraph 17 is page 333.
That is ground R.
Our patience. However, page 333, 1, 2, 3, 4, 5, 6.
Yes, but that is not paragraph 17, Malad. That is
343.
Yes.
343.
Malad, the top of 333, top line. Can you take the top two lines? First, Learned Advocate General for the state of West Bengal that the NFSA has not yet been fully implemented in the state. These two lines is same as paragraph 17.
Yes, but without this bottom portion. Now,
This is the ground.
now come to
Yes, that in the wherein in ground R of page 54, it has been stated that the Honorable Division Bench was wrong in recording.
wrong in recording. So if there is a wrong in recording, what are you
Well, wrong in the recording in the context of Abdul Majid matter.
the context?
Well, the ground has to be seen in the context of that matter. Well, the ground cannot be seen in the context of this
Can
matter.
a ground be different in a same ground be different in a different context? What are you
Well,
saying?
the considerations in Abdul Majid was only
Whatever the
restricted to Duare
consideration,
Ration.
You are saying that recording is incorrect. What is the recording? It has not
Not
yet
been yet
fully
fully implemented.
You're saying that is an incorrect recording. Then tell us what is the right recording.
Well,
Mr.
has been
Vadavati,
recorded in the context of that matter.
Tell us what is the right recording.
That the NFSA has not yet been fully implemented in the state.
Right. Now you've taken this point before the Supreme Court. Get it clarified.
But the Supreme Court has not given any pronouncement. If I today go before with a clarification application, the Honorable Supreme Court will say, subject to your correction by your Lordship, that we have not passed any order. Why are you seeking a clarification from me? It is your pleading. What will I do?
Your pleading will not go for rectification.
But the matter has not been taken up for consideration today.
There must be an application on record. We are not asking that the Supreme Court will go hand over to chief the court. But there has to be a positive action on your part.
But on the contrary, what I was submitting is that there is a submission by the Learned Advocate General.
Tell us whether you have filed any sort of application.
No. For expunging that ground, no application has been filed. Our position is that of the first two lines of page 333, submission in paragraph 17 recorded, and the affidavit of 13th of August, which has been filed pursuant to the direction of this of the coordinate bench, 13th of August, and also another affidavit which has been filed on 10th of March 2025. All resonating the same point that NFSA has not yet been fully implemented.
We are not questioning that.
I can, but I have to distinguish the judgments which have been relied on.
Well,
At least
before that, my lord, so far his submission is concerned, my lord, I will just give you five.
Oh, again.
No, again,
Again, it
no.
will never be concluded.
No, my lord, only thing.
Clarification from
Yes, my lord has already made an observation. Yes, I will.
that we have heard you. You have cited judgments.
No, that apart, Mr.
That apart, Mr. Senator, no further submission.
Again,
No,
after
on
reply.
submission, my lord, kindly take note of it. My lord, kindly just give me 5 minutes.
No.
5 minutes, because 2013.
This way matters cannot go on for
Absolutely. My lord, only thing, 2001 circular, that is the central government's and 2015. These are all. These are all my lord, under section 3, not under section 5.
We have heard you. In that aspect, we have heard you.
Because
Judgment you referred.
State has made that argument. State has made that argument.
Yes.
Section 3 and section 5 argument, state has made that argument.
Yes, no, he argued another, he produced before us another judgment.
Yes, 2 judgments. And my lord, before that, kindly give me just 1 minute time.
No.
Mr. Sengupta, this way we are fed up. This way he cannot indefinitely.
I am not, sorry. But my lord, see, whatever he has totally misconstrued the law regarding section 3 and section 5. That I will just. Section 3 and section 5 and 2 are different.
2019 SCC paragraph 31.
Is that?
You have replied another judgment, volume 9, cases 240. These are the two judgments you gave. We have taken note of your argument.
Yes. No, my lord, probably that point was because for the first time. No, justice. My lord, only thing, my lord, I have to.
You finished?
Yes. Only I just give me 5 minutes time.
But ground R I have already supplied. If you lordship kindly take note of. I have got the entire SLP, but this SLP has been filed prior to submission of the notes of argument. Prior to submission of the notes of argument, it has been, this SLP has been affirmed by the Joint Secretary before the Supreme Court on 19th August 2022. Secretary, saying whatever submitted and recorded as represented 19th August 2022.
SLP 5.
So this is prior to submission of the notes of submission. And this has been affirmed by the Joint Secretary. What it says, recording of non-fulfillment of the National Food Security Act is not correct. Meaning thereby it has been fully implemented. Vice versa, what is the meaning? And consequence. My learned friend, different consequence. What was the challenge in the duration scheme? One of the point, 2013 controller redundant by virtue of promulgation of the National Food Security Act and 2013 controller, the same issue. The division bench held, we are not considering these aspects of the matter since the Advocate General submitted before this court that the National Food Security Act has not been fully implemented.
That an order? No, that was the observation made maybe orally.
No, point has not been dealt with by the division bench, observing the same. Now, before the Supreme Court, it should not have been recorded. Meaning thereby, it is not. Yes. Yes. No. Yes. See,
there is a clamor as regards.
Yes, that is there. And now I am saying, so far the duration scheme is concerned, at that matter, we have taken this plea. The same plea, 2013 controller became redundant by virtue of the promulgation of the National Food Security Act and 2015 controller. So you cannot frame duration scheme under 2013 controller. Although duration scheme has been declared ultra virus, so for same point, not defined aspect. Kindly read my page 332. What was the challenge in duration scheme? Page 332. Inner page 4 of the judgment. Yes. Page 332 from bottom.
Why you are taking us back to that?
Why? Because my learned friend just says that different aspects.
No, he said that the context was different.
Right. Kindly take note of page 332.
Then he said that whatever the Advocate General has said before the Supreme Court, I have only reiterated this.
Not Supreme Court. Not Supreme Court, before the division.
Sorry, before the division.
Now your lordship kindly take 332 page. The context is same. Bottom portion, from bottom, fifth line, sentence start right hand side, the legality. Have you got page 332? The judgment of the impugned judgment.
Yes.
The legality of the scheme of duration, that is doorstep delivery of food grains to the beneficiaries, was under challenge at the instance of the proprietor shop, Sheikh Abdul Soanso. In the aforesaid appeal, submissions were made by the learned Advocate General of the State of West Bengal that NFSA 2030 has not yet been implemented fully in the state. Considering such submission and in view of the proviso of clause 1 TPTS Control Order 2015, which provides that Control Order 2001 would be effective in the states till full implementation of 2013, the Honorable Division Bench did not interfere with the argument advanced on behalf of the petitioner that after coming into force TPTS Control Order 2015, the Control Order 2001 has become redundant. However, the state challenged the judgment of the Honorable Division Bench. Same context. Redundant after coming into force 2015 control order, superseding 2000 control order. Same point. What the difference context? Same point. Then continue the paragraph.
Sir, where is that recording in the order of the coordinate bits about implementation? That order,
Which one?
that this one, honorable division challenging us passed before the wedding ground art. At page it stated honorable division bench was wrong in recording. Please, where is that recording?
That is, I have handed over just the SLP, one page.
No. The coordinate bench. You are irrational. Kumar.
Oh, Lord. That much I have handed over, your lordship.
Yes, please take it back and take us.
না
না এটা সেটা না এসএলপি টা এসএলপি তে থাকবে ওটা না ওইটা
Oh, that is not Dipto Kumar.
No, that is not Dipti Kumar.
Majid,
It is
Abdul Majid.
Abdul Majid.
Majid.
That will your lordship get from the SLP.
SLP. Abdul Majid's order.
That went up to the SLP.
No. Where is that recording in Abdul Majid's order?
Abdul Majid judgment I have
আমাকে
handed.
দাও না আমাকে তো বাকি আছে
Do you have?
No, in the SLP, that is the impugned order. In the SLP, it is the impugned order. It is there in the SLP. এখানে কোথায় annex?
No, SLP has not been annexed here.
No.
No, my
For
lord.
your lordship perusal, I am giving.
Verbatim has been recorded. Verbatim has been recorded by the learned single judge. Your lordship kindly come.
So then please, Mr. Shardai, give us that copy of that. Abdul Majid.
Yes. Already again I shall on the next day I shall have.
No, not the Supreme Court bit.
No.
Mr. Bandhavadhyay, give us.
Para,
Yes.
para 25, just above 26. Just above para 26.
But page 35. Kindly come to paragraph 25 first. Kindly come to paragraph 24, page 34. It starts from page paragraph 24, page 34. Now coming to question number 3 and 4, framed supra in paragraph 6. It is found that the governor, by invoking power under section 3 of the Act, has amended the Rural Controller 2013, Urban Controller 2013, obliging the fair price of dealers therein so and so. I am reading paragraph 24 of senior page.
Abdul Majid. Of Abdul Majid.
Then kindly come to paragraph 25.
Yes.
The main thrust of argument of Mr. Kaur, learned senior counsel on behalf of the petitioner, is that after coming into force the Control Order 2015, the Rural Control Order 2013 and Urban Control Order 2013 have become non-existent. The same issue as the Central Control Order 2001 has been repealed by the Central Control Order 2015, hitting at the very root of the existence of Rural Control Order 2013 and Urban Control Order 2013. The same issue, same point. From reading of Central Control Order 2015, it is however found that it has made in exercise of the power conferred by section 3 of the Act and supersession of the Control Order 2001. In clause 2 of the Central Control Order 2015, it is specifically provided that provisions of the Central Control Order 2001 shall continue to have effect as against the corresponding provisions of this order in any state which has not implemented the Food Security Act, implementing said act. But same issue, same point. Next, Learned Advocate General submits that taking into consideration the mechanism which has been provided in the National Food Security Act and the Central Order 2015, like monitoring, etc., the NFS Act has not yet been implemented in full in the state. It is submitted by Mr. Kaur, learned senior counsel, appearing for the appearance that the NFS Act has been implemented in full force in the state, and thereafter only the duration scheme was made. When Learned Advocate General, being the highest officer of the state and supported to be know the facts of submission of NFS Act, has not yet been implemented in full in state, in absence of positive amendments in the pleadings, in the repetition by the petitioner appearant, we cannot simply deny the assertion made by the Learned Advocate General. Clause 2 of the Central Control Order 2015 clearly negated the contention raised by Mr. Kaur learned senior counsel appearing for the appellant, and it cannot be held that the rural control 2013 and urban control 2013 are non-existent in view of the supersession of controller 2001. And paragraph 27, duration scheme has been ultra virus.
Yes, what judgment you are?
না না তোদেরগুলো ডিস্টিংগুইশ করবো কিন্তু তার আগে বলেন my learned friend has also relied upon General Causes Act.
Yes, yes.
General Causes Act. You will also kindly take note of General Causes Act. না আমি judgment এখন and before that, you will also kindly take up their report because my learned friend has submitted report. 2 reports have been filed. First report affirmed on 13th August 2024. What is the submission? 13th August 2024. Almost they have admitted fully implemented, but I shall show fully implemented from their document in my exception. Kindly come to paragraph 5.
That before the coordinate bench, on the basis of which the learned advocate general made the submission, when that evidence.
There is no affidavit.
Well, perhaps there is no affidavit, but I can search in my records if it is there or not.
Verbal submission.
Pretty old. It will be there in the written notes. It will be. It might be. It should be there in the written notes that I remember. The written notes which was drafted, I remember it being there. But whether affidavit is there or not.
Appeal file.
Dispose of হয়ে গেছে তো।
No, you said that the written argument was in the file.
No, it's a single bench.
That is my written notes.
In our petition.
Wherein you made that statement.
Yes, that is there. That I might have a copy also.
Record unless record call for of the petition.
We have voluminous record, no?
No. Only one matter your lordship may call.
Separate matter.
Because 17 matters were heard together. But I
there is no opposition, nothing.
I should have a copy of it.
Record may call for only writ petition and notes of submission. Thank you. Opposition নেই কিছুই তো নেই.
Mr. Bandyopadhyay, you check your records.
I'll have a copy of before the honorable single judge. I have a copy.
Then we can rely on.
Yes, but Abdul Majid, I have soft copies. Abdul Majid, which was by the learned advocate.
No, you said just now that submission of advocate general.
It is in that matter, not in this matter.
That matter was on the basis of an affidavit.
No.
Perhaps by oral
submission.
And after written note.
Please check that up. Please check that.
No affidavit has been affirmed. Only submission.
I'll check whether any opposition was filed to the stay application or not.
No. As regards this implementation and not whether advocate general made that.
From the bar.
But from the judgment itself, it appears that. কার্যে দিয়েছিস পাওয়ার ব্যাংকটা নিয়ে তাহলে খানিকক্ষণ চালাই
সব জায়গায় তো সেম স্ট্যান্ডার্ড ইমপ্লিমেন্টেড হয় সুপ্রিম কোর্টে কিন্তু হয় না
problem. That duration appeal is still pending.
Yes.
That
SLP is pending.
Yes.
Because duration scheme has been ultra virus declared by the division.
No, it has been stayed now. The scheme is continuing. The order is stayed.
Order judgment has not been stayed. State has been allowed to continue the duration scheme.
Meaning it's state.
No.
Maybe stay
Judgment
word has not been used.
Judgment has not been stayed. Court passed an order allowing the state to continue duration scheming till disposal of the.
Nothing remains of the judgment then.
Absolutely not. Different context. Judgment has not been touched.
That is this context I am talking.
In that duration scheme, in the affidavit which they filed,
No.
oh, they didn't file.
No, not in this case, not in that case. One from the word by the Advocate General, in another notes of submission. In this case, also no opposition. Only recording in the SLP by the state government. It is wrong recording. We have implemented vice versa. This is the only recording in entire all proceedings. Only recording by the government joint secretary. It is wrong recording means recording should have been fully implemented.
All right, now you are showing us this
Report.
13th August 20.
My lord, my lord. Kindly come to two paragraphs. Paragraph 5 at page 8.
অমলান 13th August বুঝতে পারছেন
August. দুটো আছে রিপোর্ট, একটা সাপ্লিমেন্টারি রিপোর্ট, একটা রিপোর্ট। রিপোর্টটা দিন।
খুলে যাবো একদম ফ্লেক্স করে
Paragraph 5 at page 8. It is the state affidavit in terms of the direction given by the coordinate bench. All the major and minor provisions of the National Food Security Act 13 are being implemented in the state of West Bengal gradually. However, there may be, kindly take note of, there may be some trivial provisions which are not yet fully implemented or they are in the process of being implemented. For example, as of 5th August 2024, about 98.31% ration cards have been linked with the Aadhaar cards, and in the month of July 2024, about 99.97% of the transactions are being made through the Aadhaar authentication process. The state government is fully committed for implementation of the provisions of the Act and is taking all possible necessary steps in this regard. Photostats copies of reports so and so. Then,
Mr. Sarai, what is your reply to this? This way they have proceeded.
No, they have proceeded. Kindly turn to my lord, two paragraphs. Section 12. A table has been given, page 2. Page 2. All they have relied on section 12 of the Act. Section 12 says reforms. I have argued before your lordship. After implementation, reforms. Reforms will continue years together. Kindly turn to paragraph 3. The sentence starts, the reforms prescribed under the different provisions of the National Food Security Act and their implementation by the government of West Bengal are delineated herein below. This is only in respect of reforms. I shall show.
Where you are
Page 2, paragraph 3. The reforms prescribed under the different provisions of the National Food Security Act 2013 and their implementation. So, implementation of the reforms. Reforms is a continuous process. After implementation, reform starts. I have placed before your lordship the dictionary meaning of reforms. Kindly read, my lord, which has been stated. First, my lord, reforms provided by NNFC 2013, Section 12(2)(a), doorstep delivery of food grains to the targeted public distribution system outlets. Flat price shops are getting doorstep delivery of food grains. Implementation. Then Section 12(b), application of information and communication technology tools, including end-to-end computerization in order to ensure transparent recording of transactions at all levels and to prevent diversion. All the works related to the TPDS are digitalized. Issue of ration card, doorstep delivery of food grains, distribution of food grains, engagement fair price of dealer, and payment of commission or papers are totally computerized. FPS automation has been implemented and thereby all FPS have been provided with a EPOS and
Mr. Sarai, what you are showing?
Their case is that except reforms, everything has been implemented. Section 12 deals with provisions of reforms, which starts state and central shall endeavor. I shall show you. Before that, your lordship kindly see all section 12. Now, your lordship kindly take up the National Food Security Act at page 209.
What you are saying?
My lord, kindly come to 209. The National Food Security Act. Up to section 8, 9, 10, all has been kindly come to section 12 at page 213. This dealt with only reforms. Their case is that some provisions of section 12 has not yet been implemented. What section 12 says? At page 213, National Food Security Act.
Yes.
Reforms in targeted public distribution system. Then kindly see the right hand side. Reforms in targeted public distribution system. What it says? The central and state government shall endeavor to progressive undertake necessary reforms in the targeted public distribution system in consonance with the role emphasized for them in this act. After implementation, reforms comes. It will continue, never ending. Next, therefrom, they are entirely in luck doorstep delivery. Well, this doorstep delivery is the reforms after implementation of food grains of the target public distribution system. B, application of information and communication technology tools, including end-to-end computerization in order to ensure transparent recording of transactions in all levels. Leveraging Aadhaar, seeding of Aadhaar number in the ration card. This is reforms.
Very good. Now, what did they say in their next affidavit?
Next, before that, you'll also kindly take up my next affidavit, my lord, also says
Anything else you want to show from there?
exception. My exception
9th of September 24.
to the supplementary. That is, my lord, affirmed on
9th September 24.
just 16th May 2025.
Exception to the supplement.
16th May 2025. Exception to the supplementary. They have submitted a supplementary report. Also a supplementary report. It has been affirmed on 10th March 2025. Supplementary report.
Yes, that is the second report.
Yes.
10th March 20.
And we have used an exception to this supplementary report.
Now, what is this 5th November 24?
This is the report. And subsequent thereto, supplementary report.
You are missing the report.
Now I want to place before your lordship the exception. Exception.
You placed before us report 13th August.
Yes. Thereafter, another supplementary report by the state.
There is another affidavit of 5th November 24. What is this?
November.
September 2024.
Our affidavit is 5th.
This is affirmed by Sumon Ghosh.
5th Sumon Ghosh. So,
5th November.
but this is the original side matter. Sujata Mitra. Cost title.
No, Sitarabe. It is down.
This is the application possibly filed by somebody. But this is in respect of a contempt petition, not contempt report. There is a contempt application and they filed a report.
There is a
Not
contempt.
connected with the appeal.
There is a contempt.
Perhaps straightway kindly take up.
Contempt of the interim order in Setara Begum.
Yes. Now, you also kindly take up our exception. Affirmed on April 2025. Date is not there. April 2025, but date is not there.
In connection with that, you have filed any section 5?
Yes. No copy served. No copy served.
You have not, because state did not prefer any appeal. You have filed a process.
Cross objection.
In your process objection, you have not argued on the limitation issue. Mr. Bandyopadhyay argued in respect of Sudipto.
No. That matter different matter, man.
Which have you said anything about this cross objection? You have not given the copy of the section 5 also.
No,
You are not appearing in that matter.
yes. Section 5 have been filed. Separate.
Have you given copy?
Cause objection, section 5 have been served.
Section 5 this.
See, kindly consider the order passed by the Justice Bakshi Division Bench. Justice Bakshi Division Bench. Justice Bakshi
Section 5 have never been served. Let my learned friend show.
Yes, my lord. I am filed.
File na. Have you served?
Section 5 appeared in the list.
Have you served on him?
Yes, my lord. Court and section 5 served.
Show the acknowledgement. Show the acknowledgement. What should I say?
I can show next day.
Last occasion also I have submitted.
Section 5 allow হয়ে গেছে?
Never allowed.
No.
I can show the order, man.
What allowed? Section 5 allowed.
On most probably 1st October 2024, when the matter was heard by Justice Bakshi Division Bench, Bakshi Division Bench passed an order. Court cause objection will be heard along with the appeal.
Does it mean it has been allowed? Section 5.
Is it a cross objection or a cross appeal?
Cause objection.
It has never been dealt with.
That point, my
Yes. No, that if that bench has said we heard along with
It does not mean my lord appeal has been admitted.
give the copy to him. Section
If your lordship allow the section 5, I shall not stand. But the submission that it has been served, it has been already allowed, this is not correct.
Yes, anything else?
So far the exception is concerned. Next day, my lord. Right.
And Mr. Bandyopadhyay ascertain that affidavit copy filed on behalf of the state in Duare assignment.
Or not, yes. Whether it's filed or not, that
Any affidavit at all was filed.
in the stay, it may not have been. In the stay, it has not been filed, but there were two matters, Manwar Ali and Majed Ali, Sheikh Majed, before the two different single benches. In that, affidavit was used. And that same affidavit formed part of the stay application. Perhaps in the stay, before the division bench, no affidavit was separately filed. Because in both the schemes were upheld, the petitioners were in appeal.
Very good. If you get that, you bring us to
And the written notes filed by the state before the honorable single judge.
Next day, I shall only show my lord the exception. And then that.
And the judgments you
Yes, distinguish. Try to my.
We will not stop anybody from making some submission, but allow us to complete.
Yes. On next day, it should be
I will
complete.
just kindly give me 5 minutes.
No, you take 10 minutes, but finish it off.
Yes.
Again, he will argue. Again, he will argue. Again.
Oh, not argue.
Well,
Just
None should. Even Mr. Shahara should not start from the
yes.
beginning. But my lord, we have filed these two
I am
affidavits.
giving reply to the queries of the
Dealing with the matter for a substantial
Yeah,
period. It's totally new to us.
Absolutely.
Unfortunately, it has been assigned. So anyway, we have to take.
Unfortunately,
Fortunate
for us.
Yes. Fortunate for us.
My lord, may I?
After getting the order, if you become sad.
But that is a different thing. My lord, may I?
Lord Denning is
May I say one line? My lord, this supplementary to supplementary affidavit was filed. This one on 10th of March. 10th of March. One is the box chart that Mr. Shahara was placing. Then we filed a supplementary to that.
Yes.
Because our point before the Honorable Division Bench was that at that point of time, that kindly do not see the situation today. see the situation as on the date of challenge, because it's a dynamic process. The situation may change today. If the matter is pending for 3 years, maybe entire NFSA will be implemented.
Already you put in a note to that effect. In any point, if we miss out,
My lord, Mr. Shahara has harped on paragraph 17 so much. I am afraid of filing notes now. As if I have done some blunder by
You own the case by
I-
filing notes.
I said something which my leader in another matter said. I only reiterated that. But
Absolutely.
Mr. Shahara did not find any other point. He kept on harping paragraph 17, paragraph 17, paragraph 17.
You
My
own
lord,
the case.
Neither is he replying on section 3, non section 5, nothing. Only
Everything I have replied.
my lord, 3 matters, that is item number 57, 59, and 60 also assigned and in similarly placed lordship. So can it be tagged?
take it up along with
Yes, your lordship, item number 57, 59, and 60.
that. That is
Those
not
3 matters
really-
are today's list.
But in those matters, there is no stay.
There is no
In
stay.
so far
On
my
this
last
matter, there is
saying,
no stay,
so
lordship.
stay.
So
Mr. We will dispose of all the
Are
matters.
this
Why
yes,
not?
sure.
But there
Let the
are
matter
some-
be tagged
some
together and
matters
only
of
one
the-
day may be given to us for our
day,
argument, lordship. Only
About
I led
day.
by Mr. Sobosai Chatterjee in this matter, lordship. Because there is some
Because
certain
Mr. Sara is
He has
started
argued
saying-
at length.
Yes, yes, argued at
lordship.
length.
Well, lordship.
Just have a consultation with Mr. Shara if any point.
No, in
is
one matter, Mr. Sada is my fibre respondent in my matter, lordship. Out of that matters, lordship, one matter, Mr. Sada is a private respondent.
then Mr. Shahara should argue that matter because that will be in our favor. Where he is appearing for the private respondent.
These are different matters.
No, now it is
Challenge the control order 2013. Now, subsequently, one subject to the vacancy notification, one license has been issued in favor of someone.
License has been granted.
Now, lordship, then the DT was filed. There is an order of status quo at the first instance. Subsequently, he come with pair with the added respondent, and that was allowed. And then my stay order was vacated, lordship. And subsequently, I am challenging the same. This writ petition has this appeal has been
stay
filed.
order vacated because
On that time when this writ petition was filed, they have already granted with the license.
By suppressing the facts, order
I
has
have
been not sent.
lordship, state was represented. State does not say that we have already issued a license in favor of someone, lordship.
we are keeping it on 2nd September.
So,
Want to
lordship,
add in a word, please add.
yes, your lordship. On that day, I will add, lordship.
But in case of my application,
So, and we will please finish your.
Yes, yes.
I have no further
submission, but I have nothing more to say.
I have no further submissions.
I'll
Madam.
I'll
These,
just adopt
some
the
of
sub-
these batch of
I shall
are
only
by the MR dealers and some by the fair price shop dealers.
MR distributor and fair price shop.
Some MR dealer.
Yes, dealers have not come. It's only the MR dealers.
MR dealer and AP shop dealers are same.
MR dealer.
MR distributor and MR dealer or AP shop dealer.
What if we shall?
Fair price shop dealer.
Fair price shop dealer.
Previously, it was MR dealer. Now it is fair price shop dealer.
Distributor, dealer.
Distributor and dealer. You
dealer.
have to kindly take note of distributor and dealer.
So appeals have been filed, some by distributor, some by dealers.
Yes.
Absolutely.
In my case, all are the dealers. 3 cases, they are the dealers.
তোরটা শুনবে তো
শুনবে মেইন আর্গুমেন্টটা তুই করবি
Mr. Shara will undertake.
আমি কেন বলো সিনিয়র
Then it will. order we have extended till November.
Lordship, I serve the section 5, Mr. Sir.
Madam, my application may be allowed, can 3,
No.
for intervening.
Second service.
We will hear you, Mr. Ghosh.
Much.
Your application is in.
Yes, yes, can 3, it is always on the list.
Thank you.